I think to start off with, I'd like to welcome Eddie up to the stand, and he'll kind of give us an overview.
Thank you, Mr. Chair, and members of the committee. My name is Eddie Pinner from Legislative Research, and I'm going to give an overview of the legislative history as it relates to the streamlined sales and use tax agreement. For the actual kind of administrative history and the history of the agreement itself, and the governing board later conferees will give that history. But this will just be the legislature's work in enacting legislation specifically, none of the other types of work that you all have done. And Sean, is that going to pop up here in a minute? Okay. I'll go ahead and start talking before it gets up there, because it doesn't really, the first bit of information doesn't necessarily help anything. The legislative history on this kind of reaches back to the year 2000, and that is when, prior to that, I believe the National Conference of State Legislature and the National Governors Association had kind of indicated some interest in putting together a project like this, and that might be touched upon by some later conferees, but the legislature first took it up in the 2000 session. And in that session, the legislature enacted Senate Bill 59, which was kind of a sales tax omnibus bill. It included a number of different sales tax provisions. One of those provisions was the Streamlined Sales Tax Systems for the 21st Century Act. And that was kind of the legislature's first bite at tackling this issue via legislation. That act didn't actually take a lot of substantive action as it related to the sales taxes themselves, but rather it kind of authorized and directed the Secretary of Revenue and the Department of Revenue to enter into discussions and agreements with various other states about developing a sales tax system that would incorporate taxes on remote sellers. The bill also adopted kind of specific legislative findings related to the issue and the idea of having competitively neutral taxes and sales tax system, and the interest in the long-term preservation of the sales tax base and how that might be impacted by these sorts of issues. It also created a short-lived, just because it was statutorily sunset, legislative oversight committee for this process. That work that was done by the Department of Revenue and various other states kind of went on there for about a year and a half or so, and then by the time the legislature came back for the 2002 session, it was pretty close to an agreement, and it was kind of shaping up what this project might look like. And so in 2002, the legislature passed Senate Bill 472. This was a specific bill for streamline. Unlike most of the other pieces that I'll touch on today, this one wasn't kind of an omnibus piece of legislation. This was a streamlined legislation. It authorized the Secretary of Revenue on behalf of the Department of Revenue to become a signatory to a multi-state agreement, and directed the Secretary and Department to prepare for its implementation, essentially by requiring the department to identify all of the necessary changes in statutes and regulations that would be required to meet the compliance provisions of any ultimately entered into agreement. It also authorized appointees of the Secretary of Revenue, or the Secretary or his or her designee, the Speaker of the House, the Senate President, the House Minority Leader, and the Senate Minority Leader, or their designees, to attend any meetings related to this topic and represent Kansas at those meetings. By 2003, the 2003 session, the agreement had been adopted and signed. That happened in November of 2002. And so the 2003 legislature enacted House Bill 2005. That was a bill that contained numerous tax provisions, sales taxes, and other taxes. It was kind of an all-tax omnibus bill. Included that were the substantive changes related to the streamlined agreement were kind of the real substantive changes. This is the bill that had the bulk of the substantive changes to Kansas sales tax laws necessary to implement this agreement. Those included some sourcing rules, the concept of being a destination-based sourcing state or an origin-based sourcing state. Some later conferees, I think, will touch on exactly what that means and its implication for taxpayers and retailers. some statutory language regarding a uniform state and local tax base, and then numerous definitional changes to definitions throughout our sales tax code to bring us into compliance with that November 2002 agreement. The 2004 session did have some kind of follow-up legislation on that. This wasn't necessarily required to be in compliance with Streamline, but it's one that was enacted to kind of help Kansas taxpayers get there. This bill included a variety of tax provisions similar to the other pieces. One of those was kind of a transitionary period and a waiver of penalties and interest period during that transition for retailers transitioning from the origin-based sourcing that we had previously used as a state to the destination-based sourcing that was going to be kind of our baseline sourcing rule under the Streamline Agreement and prospectively. And so there was a kind of an 18-month transitionary period there, the latter half of 2003 and all of 2004. And basically in that period, as long as retailers were doing what they thought was right, the Secretary of Revenue was kind of authorized to waive any penalties that would have accrued for lack of compliance if there were mistakes made in that transitionary period. And that for a while was kind of it for the legislature with Streamline. However, in terms of statutory changes, of course, in 2007, I believe in the intervening time period there had been some changes to the Streamline Agreement, amendments that had been incorporated at the amendment level, and Kansas was in a position where in order to remain compliant with the Streamline Agreement, we had to update a few of our own statutes. And so there were a handful of provisions in 2007, Senate Substitute for House Bill 2171. This was another sales tax omnibus provision that just happened to include a few Streamline relevant provisions. There were some numerous definition changes. There was kind of a modernization of our sales tax system related to addressing tax jurisdiction boundaries. Basically, between the previous version and this, the computer science ability to map sales tax boundaries had improved, and this was really something that we probably needed to do anyway in light of that modern technology, but Streamline kind of became the impetus for us to do it. And then we also enacted some liability protections for retailers and customer service providers in the event that the Department of Revenue had kind of given its blessing to their software and said, yes, this looks like it does accurately reflect the Kansas sales tax statutes and regulations, but in the event there was some sort of issue where it wasn't actually doing that, there was liability protection granted to those retailers and providers. And the only note that I have here is that this was the first set of Kansas statutory changes made kind of in response to Streamline changes. And there was only one other instance of that, and that was in 2010. Senate Bill 430 was another one of those tax omnibus bills, and it included a handful of other kind of legislative updates made in responses to amendments to the Streamline Agreement since that time, and that included some kind of further liability protection for retailers and customer service providers, kind of in the event that there was a disjoint, is maybe the best way to describe it, but they were acting in good faith. And then also some updates to the way Kansas did its sales tax exemption certificates that were required under the Streamline Agreement. And that is actually kind of the last time that the state legislature has had to legislate kind of on this topic. And since I think most members of this committee weren't here in 2010 or prior, this probably none of you have really ever legislated directly on the Streamline Agreement. I don't know, none of you. Maybe I'm getting a look that maybe one of you was here at that time and does remember some of that legislation. But the bulk of you, at least, really have never passed a bill saying, yeah, we want to do this for Streamline compliance reasons. And so that is all I had, and I'm happy to answer any questions on that legislative history. But if there are agreement history or sales tax history, I think the later conferees would probably be better suited than me to respond to those.
Thank you, Eddie. I don't think I realized the process that Kansas went through to adopt this. It's really had a lot of eyes on it over the years, and a lot of work been done. But committee, are there any questions for Eddie? on the legislative history? Seeing none, thank you very much. Next, we'd like to welcome to committee Secretary Burkhart from the Kansas Department of Revenue.
Thank you, Mr. Chairman, members of the committee. Hopefully you have in front of you a 4-page memo from the Department of Revenue, which will provide you some information about Streamlined and how the Department of Revenue is involved with Streamlined. Before I get into that, I do want to acknowledge Amy Kramer, one of the department's financial economist, who basically was tasked with gathering all of the data from various sources, including Streamlined, for you. And again, I hope by the end of this 25 minutes or so, you will get a sense of what Streamlined means to the state of Kansas and to the business community. So with that having been said, Mr. Penner did an excellent job giving the history of the legislative efforts related to getting Streamlined authorized in Kansas. Streamlined, I guess my long history with the tax issues in Kansas, Streamlined, for the most part, I thought was to deal with the issue of out-of-state retailers not being required to collect and remit compensating use tax on sales into the state of Kansas. As you all know, the Kansas or the United States Supreme Court, clear back in 1967, issued an opinion, National Bellis Hess, that basically said states could not require out-of-state retailers to collect a state's compensating use tax if that retailer had no physical presence within that state. And that prevented effectively collecting tax on sales made into the state of Kansas.
Did you say 1967?
That was in 1967. And then along came the Quill case in 1992. Back in 1967, there were no such things as computers or software, and the compliance burden was tremendous for businesses. By 1992, you saw more technology involved, and the states at that point in time, and the Quill case in North Dakota, what didn't happen by accident, that was all by design, because the states thought that the increased technology lessened the burden on businesses to comply with the collect and remit requirements. Well, that argument did not prevail, and again, Quill affirmed that out-of-state businesses had to have a physical presence in the state before that state could require them to collect and remit. So then come these other efforts to get some sort of a system in place that was simple and provided for uniform treatment among the states, which is good for the state revenue departments, but also very good for the business community. And I was speaking with Mr. Johnson before this meeting, and in my prior career before becoming secretary, I represented lots of taxpayers. And just to give you an idea what a business might be required to do, just one of the businesses that I represented had to file 6,000 sales tax returns every month because they did business in numerous states, and there were lots and lots of local units who had taxes. So this type of system is designed to help not only the states in terms of collecting taxes that are due and owing, but also the business community in making their tax collection and remittance responsibilities less expensive. It's an operating expense for them and can be very significant. So that having been said, we have been a member of Streamline for some time now. A question had been posed to me, well, what does Kansas pay to be in Streamline? What does it cost Kansas? On page 1 of my memo, it sets out our annual fees for the last 5 fiscal years, and you'll see they're around $35,000, and that's just our annual fee to be a member of Streamlined. You'll notice in FY 2021, it was basically cut in half, and that's attributable to the pandemic, and relief was given at that point. So that's the actual fees that we pay. In terms of the number of registrations, and this again these are out-of-state retailers that are registered through Streamline and remit state and local tax to the state of Kansas. You can see the growth of registrations. In calendar year 2021, we had 4,065 additional registrations in that year. The Wayfair case that was decided in 2018, which set aside that physical presence requirement, was decided on June 21st of 2018. And if you look at that chart, you'll notice that after that decision came down, the number of registrations started to increase relatively dramatically. Streamline helps to collect the compensating use tax from these retailers out of state. And in the big scheme of things, and today we're talking about Streamline and Streamline registered accounts, but when you look at the impact that Wayfair has had on the collection of compensating use tax, again, the case came down in June of 2018. That was right at the very end of fiscal year 2019. For fiscal year 2019, the state collected, and this is state general fund dollars, collected $406 million. Last fiscal year, FY 22, the state collected $775 million. That same revenue source without any sort of tax increase. And there were several causes for that. Obviously, we have significantly increased collections because we have more registrations, but some of that is attributable to increased prices because of inflation and just the fact that our purchasing public might be using the internet more to make purchases instead of going to a store. So, but the fact is there's been a significant increase in the collections, 90% increase since Wayfair came down. In terms of the state and local tax collections, again on page 2, you will see, and these are just Streamline registered accounts. For calendar year 2021, $68 million was collected. We anticipate perhaps $80 million for the next fiscal year, FY 2022. We won't know the details of that until the middle of next year. So that kind of gives you an idea of the revenues that come in from Streamline registered companies. I think that you'll get a very comprehensive review of Streamline and how that actually works when Mr. Johnson speaks to you in a few minutes. But from Kansas' perspective, this is the immediate impact that it has on the state. Just mentioning very briefly, just a quick legal consideration. When the Wayfair case was decided in 2018, it basically issued its ruling on the principle that this physical nexus requirement wasn't going to be required anymore. But that's all it did. And so there are other possible issues out there that could be raised, and the Supreme Court acknowledged that, but they said they'll deal with that when the time comes. But what they did note was there were 3 factors that they looked at in the South Dakota law that they thought were very important. And one was that there was a de minimis. There was a $100,000 de minimis, that the law was being applied prospectively to retailers, and that there was membership in Streamline. Those were all important factors, and the court emphasized those because the court deemed those to be significant in terms of reducing the burden on retailers who have to collect and remit. Kansas has all of these at this point in time. With the passage of Senate Bill 50 in 2021, we have the $100,000 de minimis now as well. So we have all of those. So if Kansas isn't in Streamlined, we've basically forfeited one possible defense if at any point in time in the future there are further challenges to the statute that Kansas is following at this point in time. So let's look at possible impacts on retailers. Again, we'll have testimony this shortly from representatives of the business community about the burden that compliance, the burden that they have to comply with particular state laws when you have a business that's operating in numerous states. The table on page 3 gives you a little information about companies that are registered through Streamline that have engaged a certified service provider. And a certified service provider is a third party that has been approved by Streamlined to basically handle the tax compliance functions for businesses. So at no cost to the business. And then how does that happen? Well, the certified service provider gets to keep a percentage of the revenues collected. And you'll see on that chart on page 3 that, say, for example, 2021, retailers who were registered and were using a certified service provider remitted nearly $40 million to the state. Now, that is Kansas and state and local taxes. The compensation paid to those retailers was a little under $2 million. So in excess of 95% of the tax that was collected would still come to the taxing entities, and the cost to the state would basically be 4.91% of those collections. So,
Mr. Secretary, those are just state numbers, correct? Or is that the CSPs nationally, or is that just the CSPs for Kansas?
that's just for Kansas.
Kansas, okay.
So, it gives you an idea of the cost to the state of Kansas to have these out-of-state retailers collect and remit through a CSP for a company or retailer registered through Streamlined. So, are there any further questions on that aspect before I move on? Okay. Impact on customers. through Streamline, there's a uniform sales tax exemption certificate that can be utilized with all Streamline states. And at this point in time, there are 20 states in Streamlined. So if Kansas were not in that, consumers would be in a position of having to get exemption certificates specific to each state in which they would be.
We do have a question here, Senator Tyson.
Yes, Senator.
Thank you, Mr. Chairman, and thank you, Mr. Secretary. The document says there's 23 states in currently, and you had mentioned 20.
I'm sorry, 23 states in Streamlined and 1 associate.
Okay.
And if I said 20, then I misspoke.
And I would ask too, just curious, I have had the opportunity to work with the Executive Director, Craig Johnson. He's been wonderful. But I noticed 2 of our neighboring states are not in, Colorado and Missouri. We've heard some great things about why to be in, but why would those 2 states not be participating? Do you have any idea? Or if research could get that to us at a later date?
I'm not sure I'm able to answer that, and that might be a question to be posed to Mr. Johnson at the right time. But and Senator, I think I'm looking at the list here is yeah, Nebraska is in. So yeah, just the 2 states, the 2 surrounding states. Okay. One of the other issues when you're dealing with customers is the fact that, you know, Kansas law requires the out-of-state retailer to collect and remit if they are above the $100,000 in sales threshold. If an out-of-state retailer does not collect and remit, that doesn't relieve the consumer in the state from having to get registered and file a tax return. You probably have never noticed, but, and it's actually taken off of our individual income tax return for this coming, well, for 2022 taxes. Because of Senate Bill 50, there used to be a line that folks could report their compensating use tax. That's no longer on there. So statutorily, there is a legal obligation for consumers if tax has not been withheld to get registered and pay tax themselves. Obviously, that doesn't happen. I think the compliance among individuals is less than 3 or 4%. It's very low, and that's just not Kansas, that's everywhere. So who do register for compensating use tax as a consumer in the state would be business entities who might make purchases and that are delivered into the state that they are using. We have obviously quite a number of corporate registrations for consumer compensating use tax who are remitting tax when tax wasn't collected by the retailer out of state. So moving on to what it means for the Department of Revenue. Obviously, anytime that returns can be done electronically, that is a large benefit to the state. It keeps payroll costs down. And when you're using a certified service provider, it's even better because say better, but as good is the fact that you can rely, the department can rely on what it's being presented. So there is an improvement in the accuracy. You know, we're more certain of getting paid. Taxes are being remitted, and then it gets easier to enforce when there's non-compliance. So the department is very much in favor of maintaining its membership and Streamlined. We think the state gets a tremendous benefit from that. the thought of having to get 9,000 or 9,500 streamline registered companies or retailers registered who are out of state would be a very daunting task. It gets difficult to enforce a law when a company is out of state and has no presence in the state. So you get into issues of having to incur costs to maybe try to enforce a decision here that's going to be enforced in another state. That increases costs. And the methodology that is used through Streamline obviously is preferable. So,
Senator Tyson.
Thank you, Mr. Chairman, and thank you again, Mr. Secretary. I appreciate the comments. I just want to make a point that, yes, it is easier for the state, but it's not easier for the small businesses to have to file all of their sales tax online. In fact, I have some businesses in my district that have to go to a library in order to file their sales tax because they do not have an internet connection, they do not have a computer. So I hope we keep these people in mind when we're moving forward with our decisions. Thank you, Mr. Chairman.
and perhaps there can be a distinction drawn between the in-state merchants in terms of their filing. Right now, about 97% of sales tax returns are filed electronically. But I understand what you're saying in terms of their capabilities. But for out-of-state retailers who are exceeding the threshold for having to file in Kansas, going through Streamlined allows them to do that with no cost. Compliance is done for them, and it's a great benefit to them because they can't be held accountable for mistakes. You know, they are in a very good situation. And again, some of the business community members will speak shortly about why businesses support being in Streamline, and it's the uniformity, the simplicity of filing. So with that, I'll conclude unless you have any further questions.
I just had a couple of questions going back to the chart. Looking at the new streamlined registrations that's been increasing, do you see kind of a forecast? Does that level off at some point with all the retailers getting filed? I mean, I know there's always new businesses opening, but do you see that continuing to increase?
I might defer to Amy on that, but my sense is more and more businesses are using electronic methodologies to make their sales. And yeah, we're probably going to have pretty stable growth in registrations. But keep in mind, again, as you pointed out, folks are getting registered, folks are dropping out. So it's constant movement. Amy, anything different?
And on the CSPs, how many CSPs are there? Are there a pretty good selection? Is there a good choice for businesses if they are in the market to find a CSP?
That is a question I'll unfortunately ask you to pose to Mr. Johnson, who probably knows them all very, very well.
And my last question is, you referred to that line on the K40 that's no longer on there at this point, but how much, do you have the numbers, ballpark on that? How much did that typically bring in for Kansas?
About $1 million.
About $1 million? Okay.
State and local.
State and local, okay. Representative Amix, did you have a question?
Thank you, Mr. Chairman and Mr. Secretary. It's good to see you. Question, you had made mention about a client that you had that would have had to have filed or was filing 6,000 forms. Once the membership happened, how many forms after that did this company have to file?
That particular taxpayer may not even be registered with Streamline, but the reason would be that particular taxpayer has an extremely sophisticated, large tax department that they are able to handle that function. Streamline, and Mr. Johnson can correct me, but my sense is that streamline benefits a lot of smaller, medium-sized businesses and helps them really control their costs. The larger companies choose perhaps to still do the filings themselves, although there certainly could be some through Streamlined. But it seems to me the size of the business makes a difference.
Thank you, Mr. Chairman. Mr. Secretary, I know that over the last 3 years that we've seen a lot of changes in businesses and how businesses are delivering services and sales. We've seen a lot of people that I think have gotten out of maybe the retail portion of their business. In my industry, I know that there's, and I'm a barber, okay? I know that there's people in my industry that have gotten out of the retail end of the business. How hard is it for a business to do away with the retail sales tax portion of their business as far as filling out forms?
So they would discontinue that portion of the business where sales tax might be collected? Well, if they aren't providing taxable sales, they technically wouldn't need to be registered for sales tax purposes at that point.
Mr. Secretary, I have constituents that call me that ask me, how can we stop that? Because there's people that find that when they fill out that form or they have to dial it up or whatever they do when they file these, it kind of sounds like you're almost closing your business if you ask to have that the filing portion of that eliminated because you're not collecting anything any longer.
Well, I guess maybe we'll look at that. But yeah, we have many, many, many businesses in Kansas who aren't required to get registered for sales tax purposes because they're not making taxable sales.
Thank you for that. The question that I have is these were businesses that did have a need for retail sales tax numbers and to remit sales taxes on sales that they had collected or taxes they collected on sales, but they no longer do that because for whatever reason they're not in the retail business. So just want to make sure it's easy for everybody.
Well, I'll go back and discuss that with our Director of Taxation, but it seems to me that that process should be relatively simple, and if it's not, we'll try to make it that way.
Thank you, sir. Thank you, Mr. Chairman.
Thank you. Senator Peck?
Thank you, Mr. Chairman. As Mr. Pinner indicated, anyone who remembers the infancy of streamlined sales tax must be a dinosaur, having been around an extremely long time. At least that's what I heard. In any event, I do recall when this was in its infancy. I was first put into the legislature in 2004. At that time, this is mostly, I want to guess, Mr. Chairman, for the benefit of the committee, and I realize that 2004 and 2022 are several years apart, but it was a significant burden on our businesses, and as indicated by the vice chair of this committee, chair of the Senate Tax Committee, small businesses particularly. It was extremely difficult, and we heard nonstop. Several legislators who were in the legislature in 2004 lost their election specifically because of this issue in the 2004 election. So it is a big deal, and so it is something that I have never been supportive of. However, I'm still listening with an open mind now because we are so far down the road, and I can see some upside, still more downside. But my question to you, Mr. Secretary, if Kansas was no longer part of the streamlined sales tax, a part of that, my recollection, was destination sourcing. If we weren't, could businesses still destination source? And what I'm getting at, for example, where I live in my county, there is no county sales tax. If I buy a load of lumber, which I have built several buildings from a lumber yard in Independence, if I go buy it, take a trailer, load up, I pay sales tax of 9.5+%. However, if they bring it to me, they charge me a small delivery fee, and I save 3% in round numbers of sales tax. So again, the question would be, if we were no longer part of this streamlined sales tax, could businesses such as that, destination sourcing, could that still be utilized, or would that still be?
Destination sourcing is part of Kansas law at this point in time. So I think that applies whether you're in streamlined or not. I'll check on that, but that's my sense.
Okay, I was just curious because at that time, that seemed to be they fit together. But if it's been separated, that would be a good thing, I believe, Mr. Chairman. But thank you, Mr. Chairman.
Representative Turner.
Thank you, Mr. Chairman, and thank you, Secretary, for your comments. Earlier, the Vice Chair asked about a couple of our neighboring states, Missouri and Colorado specifically, but I just wonder what your general thought is in terms of why the majority of states haven't jumped into streamline.
Again, I'm not really certain why that would be the case. I'm sure there are a variety of arguments why they shouldn't be in, and just like there are a variety of arguments why they should. You know, we're talking, and a lot of my comments were based upon, you know, out-of-state retailers who are getting registered through Streamline and remitting to the state of Kansas, and how they benefit from that in terms of simplification. But keep in mind that Kansas retailers who might not have a presence, a physical presence in other states, that are selling into those states that are Streamline registered, our in-state Kansas businesses will benefit by having all of their compliance handled for them at no cost, because the other state is going to be paying the expenses of complying with their law. So there is a benefit to Kansas businesses as well.
Thank you, Mr. Chair. So on the topic of certified service providers, CSPs, it looks like you said that businesses could use them no cost, and it looks like the compensation to those CSPs is basically being a discount rate taken from the state, right? So the state paid, I'm seeing in 21 about $2 million essentially in lost or foregone tax collections for that service. And what is the benefit to the state that justifies that we're given that kind of a discount to that industry? Thanks.
First of all, we're actually having compliance, and we're receiving over 95% of what was collected. And if those companies weren't registered through Streamline, whether the state of Kansas, through its Department of Revenue, could go out and enforce the law as efficiently for less than $2 million against all of these entities outside of the state of Kansas. It gets very tricky when you are dealing with entities out of state that have no physical connection with the state of Kansas in terms of our jurisdiction to get into court to enforce the law against them. So what do? We have to file out of state in a court in another state and hire outside counsel to do that. Enforcement becomes very, very difficult and costly.
Senator Erickson.
Thank you, Mr. Chair. Thank you, Mr. Secretary, for being here. Just to follow up on Representative Turner and the Vice Chair's question, are there any comparisons to collection of states that aren't members of Streamline, specifically Colorado and Missouri? Are there any data to show the comparison between those that belong and those that don't?
I'm not aware of any.
I'm just going to throw this out here to think. I don't know that we have data on that, but, and I think Craig can get into this in a little more detail, is there tends to be a divide between the big states. You don't see California, you don't see New York, you don't see Florida on that list. And then the streamlined states is Kansas, Nebraska, Oklahoma, the Dakotas. There tends to be a big state, small state. divide between who does streamline and who doesn't.
Thank you.
And that might be part of the reason why Colorado and Missouri, that just population-wise and metropolitan area-wise are different than Kansas, Oklahoma, Nebraska, why they've made different decisions than Kansas has.
Thank you, Mr. Chair. Quick follow-up. It would be interesting to see the comparison between collections and costs and fees with a comparable as we can state of Kansas, which I would think that we could find one since the majority are not part of this agreement. Another question, if I may, Mr. Chair, quickly. On page 1, the streamlined dues, what are those fees based on? Is it collections or the number of tax accounts?
Those amounts are determined by the governing board every year, and we have members, Senator Tyson and I'm trying to think, I think Representative Croft and our Director of Taxation sit on that board. So the fees are determined by a board, not necessarily based upon recovery amounts or anything of that nature.
Okay, thank you. Thank you, Mr. Chair.
Representative Kessler, did you have a question too?
Yeah, thank you, Mr. Chair and Secretary. I just wanted to back up for just a minute here when we're talking about the compensating use registration for consumers. Since Senate Bill 50 on that eliminated the line item, does that mean the consumer has to register just as a business does?
That is correct.
And file for a registration certificate?
KSA 793705A basically requires a consumer who has made a purchase where compensating use tax was not taken out or was not charged by the retailer, has an obligation to register and file a return and remit.
Okay, so as a business, if you have a compensating use registration, that is a monthly filing. Even if that monthly is zero, it's still a monthly file, correct? Is that the same with the consumer? They would still have to do a monthly file even if it's zero?
It depends upon the amount of the, on the amount of the tax that would be remitted. We have monthly, quarterly, and annual filers. So if it's a very minimal, you file an annual return.
On the consumer side?
On the consumer side, and my is it 400 now? So if the actual tax liability is 400 or less, you file an annual return, and I think that goes up to 4,000, perhaps on quarterly, and after that, it's just monthly returns.
Thank you.
Any further questions for Department of Revenue? Seeing none, thank you very much.
Thank you.
At this point, Craig, do you want me to introduce you or the whole crew, or do you want to, we'll have Mr. Johnson here from Streamlined, and we also have a couple of virtual attendees. They will be going through a fairly lengthy presentation, so I do want to say if you want to make any questions or comments, let's go ahead and address them at that point in the conversation. That way we don't get to all the way to the end and then have to go back and try to go back through all the slides. So if you have any questions, just raise your hand and I'll do my best to recognize everyone. But welcome, Mr. Johnson.
All right. Thank you, Mr. Chair. And I have to say, as I was sitting there and you were asking some of those questions, I had to kind of sit on my hands and say, I can give you those answers. So don't hesitate to ask those questions again. I'd be more than happy to provide the answers and the information that I can for you. Again, thank you for inviting me and providing me the opportunity to come and speak to you about streamlined sales tax. As Eddie said too, some of you likely were not around when Streamline started. You weren't in the legislature at that time. I was not the executive director of Streamline when it started. I was working for the Wisconsin Department of Revenue. I've spent about 24 years there, primarily in the sales and use tax area. So I am call it a self-proclaimed sales tax nerd. I eat, sleep, and breathe sales tax. That's just the way that it is. I have been the executive director of Streamline for the last 10 years, or will be 10 years in January. And certainly have appreciated all of the support that Kansas has shown us as being one of our member states. We do also have, I mean, in addition to the PowerPoint that we're going to be going through, we do have a state guide for lawmakers that is out on our website that you certainly can look at. It tries to provide the 30 or 40,000 foot level of streamline, because if you want to get into the weeds, and I think I mentioned this to Eddie and I mentioned it to Representative Smith, I could be here for 2-3 days if you'd like me to, but all of you don't enjoy sales tax, I don't think, as much as I do. And I think it's very important for this committee and really the Kansas legislature to understand that it's not just the states that are getting together to make these decisions that have happened with respect to streamline. It's the business community, and we rely very heavily on the business community and input from them on understanding what the impacts are of any of the requirements that we put in streamline or any of the requirements that are contained in the agreement. And to that end, I have two folks that are they're appearing virtually. Fred Nicely and Patrick Reynolds are both from the Council on State Taxation. They've been very involved in Streamline, and I'm going to ask them just to make sure we can hear them, if that's all right, Mr. Chairman, have them introduce themselves.
Fred, you want me to go first?
Sure, Pat.
Sure. Can you hear me okay in the room?
We
Senator?
can, loud and clear. Thank you.
Great, thank you. Again, my name is Pat Reynolds. I'm with the Council on State Taxation. For those of you who are not familiar with us, we are a nonprofit trade industry group, and our members consist of approximately 500 or so of the largest multi-jurisdictional businesses in the U.S. And our mission is to preserve and to promote the equitable and non-discriminatory taxation of those businesses. So in other words, we are not one of the organizations that says we want no tax. We are an organization that says we want fair, equitable, and non-discriminatory taxation. And the reason that we are here today is that we have been longtime supporters of Streamline, and we support the simplicity and uniformity that Streamline brings forth for purposes of not just our members, but also small businesses around the country. Fred, go ahead.
Thanks. So I'm Fred Nicely. I'm also a senior tax counsel with the Council on State Taxation, and I've been with COST for 15 years, and all 15 years, our members have been very interested in streamlined sales tax and its great efforts in trying to reduce the burdens on business and the collection and remittance of the sales tax. So really appreciate all the work of Kansas and the other streamlined states have done in this area. Before I was with COST, I was with the Ohio Department of Taxation, and I served 8 years there as the department's chief counsel. And also, very importantly, I was a delegate on the Streamlined Sales Tax Governing Board. And before there was official governing board, I was part of the implementing states that they've had. So a lot of good work has been going on, and both Pat and I have been able to appreciate both being on the state side and the business side. And with that, I mean, the last thing I have to say is you're in very capable hands with Pat and with Craig. I will be on as long as I can, but I do have to catch a flight to do a presentation in Minneapolis tomorrow. So I apologize if I have to leave early.
Craig, if you don't mind, I might ask to the Council on State Taxation, either one of you that might want to answer. You may have heard the question we had. We have a couple of neighboring Midwest states, and I'm just curious if at your organization level, do you hear some comments from members that are participants, or do you have any members that are not participants? What are some of the arguments, the pros and cons of some of our, specifically kind of the smaller Midwest states that are not members?
I think the easiest one to probably tackle is Colorado. And I think one of the biggest obstacles for Colorado joining Streamline is the number of home rule jurisdictions that exist within the state. So these local jurisdictions administer and impose their own sales tax, and Streamline requires a single administrator of sales tax at both the state and local level. And that's a big impediment for Colorado to join Streamline. Fred, do you have anything you wanted to add on that? And I guess Missouri, if we want to talk about that, we have had several good discussions with folks in Missouri about joining Streamline, and we think that there's a good possibility that could happen in the future. Fred, do you have anything to add?
Yeah, I mean, bottom line, our members would like all 45 states to be part of the streamlined sales and use tax agreement. And, you know, we want to work with Missouri and Colorado. Like Pat had mentioned, Colorado has issues with their constitution and home rule authority for the locals. Quite honestly, their system is one of the most complex out there. Missouri, you know, we'll talk about this probably more in the presentation, but we're hoping we can get Missouri. They passed some legislation already that could allow them to do a very light version of Streamline and adopt some of the key features, such as the central registration system, making it easier for sellers to register in that state. But you know, very importantly, you know, we would wish for all the states to join. We understand. I think as Senator Burkhart had indicated that, you know, some of the larger states, they feel like they can do it on their own, but there's risks with that. And we'll talk about those risks as we go through the presentation, that the streamlined states are in a much more secure position to be able to continue to have the remote seller collection as compared to those states that are not involved in Streamline.
And I think it's important to note also, and we're going to cover this in the presentation, that that since Colorado is not a member of Streamline and it does have a significant amount of complexity in order for sellers to comply with its law, it is subject to and is currently in litigation regarding the constitutionality of its state and local sales and use tax system. So we'll cover that in a little bit more detail as we go through the presentation.
And Mr. Chair, if I could add to that too, with respect to Colorado, the thing to remember about that with them not being a member, your constituents, because they have economic nexus laws in place, they have to comply with Colorado's laws. They have to file all those individual returns with the home rule jurisdictions in Colorado, unless they're going to challenge them. And that's really what Pat was touching on, was the litigation that Colorado is facing right now, is because of those undue burdens and the complexities that are there. But that's one of the things that, and I'm going to talk about that, the different perspectives we have to keep in mind as we're thinking about Streamline, we're thinking about uniformity, we're thinking about simplification, and we're thinking about state sovereignty. We have to balance all of those items out.
Well, and as somebody who lives literally 1 mile from Colorado, I'm very familiar with that, and unfortunately, the reality is that there's a lot of non-compliance, and they just don't want to mess with it, and they'll pay the penalty or the fine if they ever get caught. So,
and that's a tough spot for businesses to be in, right? I mean, to not know. I mean, I'd like to be able to go to sleep at night knowing whether or not Colorado is going to come and visit me, or Wisconsin, where I'm from, if they're going to come and visit me. And I think you have a much better chance of Colorado coming that you're not doing something right than you do Wisconsin, just because, again, we're also a Streamline member. So before we jump in, though, I would like to just make a couple of comments, if I could, related to Secretary Burkhart's comments, and really give a shout out to the Kansas Department of Revenue for all the work that they do to make sure all the different administrative provisions that are required for them to meet the compliance requirements of Streamline. The taxability matrix that they put out on an annual basis, they have to do that. The rate and jurisdiction databases, so sellers know what tax, what state tax, and what local tax to collect. They need that information. And those are things that, as part of Streamline, every one of our member states has to put that information out. And then also to you, I mean, you folks as the members of the Kansas Legislature, I mean, you've seen the benefits of Streamline, you've realized the revenues, and Secretary Burkhart certainly talked about, yes, there are some costs, but you look at what the revenues are in relation to those costs are pretty minimal. I also want to just talk about some of the things that are not measurable as far as the benefits of Streamline as we get started here. And again, Secretary Burkhart talked about the costs, he talked about the revenues. But there's a lot of impacts that you can't quantify in dollars and cents. Impacts such as, what is the simplification and uniformity provisions as a member of Streamline? What has it saved your Kansas-based businesses in terms of complying with the laws? in terms of complying with all of the laws of the other states that are members of Streamline that do things uniformly. That directly benefits any of your Kansas-based businesses that are making remote sales into those other states. And I think that's something we can't lose sight of. The amount of resources, time and money that the Department of Revenue saves because they don't have to worry about as much enforcing their laws, collecting the dollars of these remote sellers because they voluntarily come forward. If you weren't a member of Streamline, I can't tell you that they would not definitely collect your tax. But what I can tell you is I am extremely confident, based on my conversations with sellers, that there are sellers that are out there that are collecting because you are a member. If you were not a member, as they were doing in a number of states, they keep their heads down. They're trying not to make sure that they don't get on somebody's radar and that they don't get caught. That's not a great way to do business. That doesn't give them certainty and clarity. And ultimately, if every state goes after them for remote sales and they haven't been collecting, what does that do? Puts that business out of business, and potentially one of your own Kansas-based businesses is now gone. So you lose that revenue as well. So I think we have to keep those things in mind. And last but not least, you know, one of the benefits that Kansas receives, and it's really all of the member states, is leveraging the knowledge of 24 member states and the business community when you're making decisions on changing your tax laws and what the impact of those decisions are on the business community and on the state. You know, we've been working with Senator Tyson recently. And Senator Tyson was interested in coming up with an amendment to the agreement that would allow the state to exclude the reimbursements that retailers receive from their taxable sales price for basically manufacturers' coupons. The agreement didn't allow that because we wanted to keep that uniform so retailers across the country would do things uniformly. And I think it's fair to say, and Senator Tyson, certainly correct me if I'm wrong, but I think what sounds like a very, very simple issue, once the question was put out there and multiple states looked at it, the business community, Fred and Pat and their organization, small businesses, large businesses alike, looked at it, it opened up a whole host of questions and issues and potential complexities. And the business community is really looking for clarity and certainty. They want to make sure that if the law changes, they know what they need to do to implement that change. And they also need to make sure that it's administrable. At the same time, we have our states that are participating in there, and they're doing the same thing. Well, if this happens, how are we going to be able to administer it? So those are some of the intangible benefits that you get also from being a member of Streamline. It's not just the dollars and cents, I will say, but certainly that is something people can see. That is, again, the tangible benefits, but there's a lot of intangibles that go with that as well. So with that, and I think is my presentation set to go? We'll go through the PowerPoint itself. As I get it so I can advance the slides. There we go. So let's talk a little bit about the agenda, and Fred and Pat and I will be jumping back and forth. Again, I think, Mr. Chairman, you were okay with that. I think you appreciated it. And the fact that, we have a lot of different information coming from the state side versus coming from the business side, and addressing that all at the same time is great. And again, I would ask that if you have questions, certainly feel free to stop me and ask those questions as we're going through it. So with respect to the agenda, we're going to talk about what is Streamline. Why was Streamline started to begin with? Who's involved? What makes systems and the state sales tax systems burdensome? What have we done to remove some of those burdens? What were our goals and what are the results of those goals when Streamline started and the states and the business community came together? Talk about how we're governed. I know there were some questions about how the dues were calculated. We'll talk a little bit about that. I can explain that further. The key features of the agreement, the certified service providers. I think people always have questions on what it is, why it's a benefit, because there is a cost associated with that. But I think you'll see that the cost is well worth the return that you get on those dollars. And then the Wayfair decision and subsequent federal activity. That is something that we have been I don't want to say concerned with, but it's something that we have been watching very closely as far as what's going to happen at the congressional level potentially since the Wayfair decision. And then our successes to date and some of the current projects, so kind of where we're going, what we see Streamline doing in the next, say, 5 years or so as we continue to move forward. As we're talking about these materials, I really ask you to think about this from multiple perspectives. You know, you've got the state perspective, you got your legislative perspective, you got the Department of Revenue's perspective, and you got your in-state businesses, the ones that have physical presence. Prior to Wayfair, when you made a law change, it affected your in-state businesses, it affected your Department of Revenue, it affected you as a legislator, depending on what the decision was to do on how it would or would not help a constituent. In a post-Wayfair world, now you have to be thinking also about the remote seller perspective. Every seller that's outside of Kansas and shipping a product into Kansas that exceeds your economic nexus threshold has to comply with your laws, just like your in-state businesses do. So when you're making a change here, the businesses up in Wisconsin have to be watching that. They have to understand what that change is, and they have to build that into their system as well. And then you have your own constituents, your Kansas-based businesses that are making remote sales throughout the country. If every state legislature around the country did everything different, imagine what your own constituent would do to try to comply with all of those laws if they were making remote sales and exceeded the economic nexus laws in each one of those states. So that is a big change for you, I mean, from a legislative perspective in a post-Wayfair world, is making sure that you realize that everything you do affects every seller that's collecting any dollar of tax, regardless of where they're located. And that is something that I know Fred and Pat in particular are very concerned with and watch very closely for their members and for members of the Business Advisory Council. And again, and I understand the state sovereignty issue, and that's really, when we talk about some of the goals of Streamline when it first started, that was the issue of how do you balance simplification and uniformity with state sovereignty. Every time you require something, doesn't that take away a little bit of that sovereignty? But if you don't require certain things to be uniform, then all of a sudden you increase the complexity. So where do you find that balance? That's extremely important. We are not about telling you what to tax and what not to tax. A lot of what we do is from an administrative perspective and creating uniformity in the administrative processes and procedures. We believe that it is the state legislatures that need to decide what to tax and what not to tax. We will talk about uniform definitions, and we will ask you to either tax everything in that definition or exempt it. But at least what falls within a definition in Kansas falls within that same definition in every one of the other member states. And the reality is non-member states are starting to look at Streamline, and a number of them have adopted the definitions that we have in Streamline because they've seen that it works. So we know that that's happening. They may not be members, they may not be showing up as members, they aren't using a certified service provider, et cetera, but they're still following a lot of the requirements of Streamline. And I don't know, Fred or Pat, did you have any comments on that?
Yeah.
Go ahead, Fred.
Yeah, I was just going to say that I think what's really important is you look at the Streamlined Sales and Use Tax Agreement, in-state sellers and out-of-state sellers, they're all treated the same. The benefits and the protections that are out there, you know, the liability relief, if they're relying on the department's information, it happens to be inaccurate, that applies to in-state and out-of-state sellers. The only real difference between in-state and out-of-state sellers would be reimbursement for the certified service provider services. Where the states don't have to reimburse the in-state sellers. However, you know, all the other protections, the way the exempt certificates work and filing simplified electronic returns, all those apply both to in-state and out-of-state businesses.
And that's kind of the point that I was going to make too, is that even though we at cost represent large taxpayers, if it's simple for the small sellers, it's simple for us too. And simplicity and uniformity is one of the, or two of the driving factors that we have advocated for consistently over our tenure.
Okay, so if we talk about Streamline sales tax itself, how many of you would say you're familiar with Streamline? You know what it's about, you know what we do, you know how we do it. Anybody? Okay, and that's exactly why I think it's important for us to be here too, to talk about what we're doing and why we're doing it, how we're doing it. And again, this is going to be a relatively high-level overview. You're going to feel like you're in the weeds, but I will tell you, this is going to be a relatively high-level overview of what we're doing because of the details that we do get into. But I certainly would encourage you, and I have my contact information on there. Don't ever hesitate to reach out if you've got questions. What are you guys doing? Why are you doing that? Come on. I'm fine with that. I have no problem answering those types of questions. So let's talk about what is streamlined sales tax and why did it come about? Basically, when you think about streamlined sales tax, think about things that will remove the burdens on sellers. Believe it or not, the states get a lot of benefits out of streamline. You remove those burdens. It also makes it easier for the state to administer it. It also provides clarity. It also provides certainty for the businesses, and that's extremely important. When Streamline came together, this was an effort not only by the states, and when we say the states, we're not talking about just the secretaries of revenue. We're talking about state legislators. We have a number of state legislators that sit at the table with us, and we would encourage more of you to participate in it. It's the state tax administrators. It's the local governments. Think about all of your local entities that you've authorized to impose local taxes. The U.S. Conference of Mayors, the National League of Cities, National Association of Counties, government finance officers, they are all associations, local government associations that participate with us as well to try to understand the simplification, the uniformity, and the benefits of it. And then the business community, as I mentioned, we rely very heavily on the business community and input from them. They are the ones that are out there trying to enforce, or not enforce, they are the ones that are out there trying to apply the laws and make sure that their businesses are doing what is required. I'm going to tell you that I would say probably 99.9% of businesses, because seems like there's always some bad actors, but the vast majority of businesses try to do what's right. And again, I mentioned I worked at the Department of Revenue in Wisconsin for 24 years. I couldn't believe that anything that we would do would create a burden. It's like, it's Wisconsin law. How hard can this be? But when I took this position on and realized I went from having to understand what one state did to just having to understand what our 24 member states did, that was a huge jump, a huge lift. And then you still have 22 other states with a sales tax that do things differently. That's the burdens that businesses are facing, and that's really what we need to be addressing. So let's talk a little bit about what we do. And as the first sentence kind of says it all, what the governing board itself does.
We had a question, if you don't mind.
Sure.
Representative Turner.
Thank you, Mr. Chair. Since we're starting at zero assumed knowledge, when you say we, could you talk to me about who we are? I assume you're talking about the governing board, and where is that organization? Where are you physically at? Could you give me some of that? Thank you.
Sure. So, and we will get into more of the details of it, but I will tell you that when I say we, I am talking about the governing board, and I will tell you the governing board itself is made up of all of the member states. Each one of the member states sits at the table. Each one of the member states gets one vote. We don't care how big you are, how small you are. We don't care how much tax you do or don't collect. So it's one state or one vote per state. The organization itself, the governing board itself, we have 4 3/4 employees, and counting myself. I have 2 folks that work on the IT side. I have an assistant, and I have a director of compliance and research. That is the paid staff out of Streamline. The rest of the organization is supported by our member states. I'm going to say loaning us employees. The state of Kansas, early on when Streamline was started, you had a group of fantastic folks and still do dealing with technology and at the Department of Revenue. They helped lay the groundwork for much of the technological changes that were made, the requirements that were put in place, the formats that were put in place to create that uniformity. So that's kind of the we. Now, as far as where we're located, I will tell you, I came down here to this great state of Kansas hoping for some nice weather, and I'll tell you, this is nicer than where I came from. I am up in Wisconsin. I always tell people I am on the west coast of Wisconsin, up on the Mississippi River, up by La Crosse. So that's where the world headquarters of Streamline is located.
We also had another question from Senator Tyson.
Thank you, Mr. Chairman, and thank you, Executive Director, for being here. It's nice to see you in face or in person. I would ask, who is the voting member or the representative from Kansas? I bet this committee would be hard-pressed to know who is making that decision for our state, those decisions. Thank you, Mr.
Sure. So each state is allowed to appoint 4 delegates, or up to 4 delegates under our bylaws. Each state then passes your own laws to say, here's who we're going to allow to represent the state of Kansas. The state of Kansas, the Secretary of Revenue or his or her designee is allowed. Is a member from the Senate, and Senator Tyson, you are the delegate. I know we got a letter from the Senate president is the one that makes the appointment, and they send it. And then there's also a representative, I believe is it Representative Kraft or Croft?
Croft, probably.
Yeah, I believe is on the Assembly side or on the House side. So those are the folks that are there. Now, typically what we have, and early on, there was much more legislative involvement because when Streamline started, it was going to require significant legislative changes in states. So there was a lot of legislative involvement. Now it's more of, we're kind of tying up loose ends, evolving the agreement as it needs, as technology changes, as industries change. You look at how there's been a transformation from selling tangible personal property to digital goods. That's a big change. And how do the states keep up with it? How does Streamline keep up with it? So those are the things that we do now. Now, when you have multiple delegates, each state gets 1 vote. And the delegates have to be together on, this is how we're going to vote for our state. And that we leave up to the states and then to the delegates to say, here's what our vote's going to be. Or you decide when we're going into the governing board meetings, here is who's going to be the voting delegate for our state. We do not say it has to be Senator Tyson or it has to be Secretary Burkhart. We say that's a state decision as far as who you want to and how you want to represent that. Okay, so what do we do? And again, we as the governing board staff assist states as they administer a simpler and more uniform sales and use tax system. And really, if you go to our website, what you're going to see is right on the front of our website, states and businesses working together to create simpler and more uniform sales and use tax systems. That's really what we're about, simplification and uniformity. And again, we'll talk about balancing that with the state sovereignty issue itself. So why was Streamline created? And I think, Pat, you were going to take the lead on this, correct?
Sure, and I think this is one of the keys to understanding Streamline in terms of its background, and Secretary Burkhart kind of touched on this a little bit as well with his talk of the National Bellis Hess decision at the U.S. Supreme Court in 1967, and subsequently with the Quill versus North Dakota decision in 1992. And those decisions stood for the proposition that in order for a state to require a seller to collect its sales tax, or in this case, compensating use tax, that seller had to have physical presence in that state. And that was the case for 50 years until the Wayfair decision, which we're going to talk about in a little bit. But the court held that to do otherwise would be a burden on interstate commerce. And, at that time, I think there was, depending on the count, there was either 10 to 15,000 taxing jurisdictions in the U.S. And the court just felt that in order to require a seller to collect the tax, that seller had to have physical presence in the state. It was an arbitrary dividing line. So a bunch of states got together, and you heard Secretary Burkhart talk about the NCSL, the NGA, and these states got together and tried to simplify their laws and make their laws so much more uniform that one of 2 things would happen. Either one, they would go to Congress, ask U.S. Congress to exercise its Commerce Clause powers and require states or require sellers to collect the tax if the states have undergone certain simplifications. And we're going to talk about that legislation here in a little bit, and we know that that didn't happen. Or number 2, which did happen, was take another run at that U.S. Supreme Court decision in Quill and try to get it overturned. And that's ultimately what happened with the Wayfair decision. So I think that Quill decision is a huge backdrop for why Streamline exists today. And we're going to talk about this a little bit later, even in the post-Wayfair era, is it still important to have around? We think it is, and we're going to go through those reasons in a little bit.
And Pat, just adding on to that, the Quill decision, the U.S. Supreme Court was very, very crafty on how they wrote that opinion. And they addressed two important constitutional restrictions imposed on the state. One is the Due Process Clause, and the other is the Commerce Clause. And under the Due Process Clause, you're looking at fundamental fairness, whether or not there's sufficient activity in a state. The U.S. Supreme Court in the Quill decision didn't say there was a due process clause problem. They ruled on the Commerce Clause. And what's really important about it being a Commerce Clause restriction and really just retaining the physical presence back in 1992 is that Congress has the ability through the Interstate Commerce Clause to be able to broaden a state's powers. They can restrict also, but they have the ability to broaden. So that's why you saw after 1992, there was a lot of efforts, both from the state and the business community on, well, maybe we can get Congress to address these issues. And we'll talk about that later. But, Quill was kind of unique in the way it was written by the U.S. Supreme Court.
I think too, as Streamline started, businesses were recognizing we don't have a level playing field. I'm a brick and mortar business in a state. I have to collect tax. My competitors are coming into my state, shipping products into my state, not collecting any tax. So what did consumers do? I was guilty of it. Once you had that smartphone, you went into the store and you said, hey, look, I can go buy this. And let's use the giant elephant in the room, right? I can buy this on Amazon and it will only cost me X number of dollars. And they will ship it right to my house. Can you match the price? And retailers started doing that, right? They price matched. Then consumers got smart. They realized that just because I was able to buy that from this out-of-state company for a lower price, they started to realize I still owe the tax on it. I still have to pay that use tax. And as we all know, we know how well sellers or purchasers were paying that use tax. Again, I can tell you in Wisconsin, it was less than 1% of the returns had use tax. And we had that same use tax line on there that Kansas has. We collected between $1.5 million and $2 million a year on it with just 1% of our sellers. But then sellers started going to the business, or consumers started going to the businesses and saying, now we want you to match the price after tax, because they realized they owed that tax. So whose pocket were they asking that tax to come out of? They were asking the retailers to take it out of their own pockets and in effect pay that tax for them to match the price that's online. And that really was, I think, a strong impetus for the business community starting to participate very heavily in streamlining, getting this moving. And then at the same time, e-commerce is growing and states are realizing we're losing revenue and what's going to happen to our sales tax base as it continues to erode. I would ask you to think about this. If the Wayfair decision was not there and COVID had happened and the shift from brick and mortar sales to online sales, and if states couldn't have required remote sellers to collect the tax, you'd be in a much, much different position today, I believe, from a revenue perspective than where you are, because you had those remote sellers now collecting the tax. But that was one of the concerns early on with respect to Streamline. Let's see if I can get this to advance. Can I have you advance the slide? Frozen up. There we go. Okay, so let's talk a little bit about who's involved again. So we are a nonprofit corporation. We are 100% controlled by our 24 member states. You as member states pay dues to us. You asked how the dues were calculated. You as the governing board, you set our budget. You all review it, you all vote on it. I put it together and propose it, and we walk through it. Once you have it approved, what we do is we take that budget and we cut it right down the middle. And we take half of it and we allocate it equally to each one of our 24 states, the 23 full member states and our one associate member state. The other half of it is based on your percentage of sales tax collections in relation to all of the other member states' collection. So the bigger states pay a higher due than the smaller states overall for that second half of the budget. Overall, the dues end up ranging somewhere from about 25,000 up to as high as almost 90,000 a year. As you can see, Kansas is right around $35,000 a year that you folks pay us. And then as far as the local governments, I mentioned that, and again, the importance of the business community. But let's talk about what makes some state sales tax systems burdensome. And I know Fred and Pat are going to talk about this from the business perspective because, again, that's really what we rely on to help identify what the burdens are. As states, we think our systems are great. We understand them. But when you have to do it for 45 different states, it creates some burdens. So Fred, Pat, take it away.
Yeah, Pat, you want me to start?
Yes, go ahead, Fred.
Okay, great. So, what we're talking about here is not the streamlined states. This is mostly the non-streamlined states and what's really creating problems for businesses. And the first one is a very important one. We talked a little bit about Colorado, and that's a state that has separate administration, both at the state level and the local level. And where that imposes a lot of burdens is that you have to do filings separately, both at the state and the local level. You have audit exposure that it's not just audits being done by the state, but also separate localities. You have registration requirements that are inconsistent. And Colorado, you have different definitions that you could have at a locality versus the state level, which creates a lot of problems. And even in some states where they have the same definitions, but they have local administration, and Louisiana is an example of that, you still, because you have two different entities that are looking at an issue, they can come to two different conclusions on whether a manufacturing exemption applies or doesn't apply. So separate state tax administration, this was one of the core values that Streamline realized very early on. Important, to the business community, and I think the states realized for them to be able to be efficient in administering their state and local sales taxes, you need to have central administration. It's also very important to know, what are the rules on who has the right to tax the transaction, dealing with the sourcing issues. And are the sourcing, is it going to be consistent state to state, or are you going to have states fighting over, who has the ability to tax first? The state has very good uniform sourcing procedures. And fortunately, I will say that some of the non-streamlined states have adopted those. So we have some cross uniformity even with some of the non-streamlined states. Tax rates varying greatly by locality in a state. That creates a lot of problems. Some states, one of the reasons why Tennessee is still an associate member states is they have some caps, some thresholds where you can buy a certain product, but if it's over a certain amount, the tax doesn't apply anymore at the local level. And that all sounds great, but that can create a huge compliance issue for businesses in the collection of the tax. So dealing with the tax rates and having a simplified structure, that is something that works best. And then, the overall tax basis. And, I mentioned Colorado, and again, that's probably the poster child for problems. And pre-written software. The state has a definition in Colorado of what constitutes pre-written software. The city of Denver does not use the same definition. So in Streamline, all the member states are using the same definitions. There's oftentimes toggles. Craig had talked about taxability, and states can choose to tax or not to tax. So there are toggles, but the definitions that are used are all uniform and consistent, which greatly helps with overall compliance. Pat, do you want to cover some of these? Do you want me to continue on?
Go ahead and continue, Fred. I was just going to ask Craig to advance the slide, which he just did. So.
Okay. So we talked about, separate state definitions from what the localities use. Again, very, very problematic. You don't have that with any of the streamlined states. The exemption certificate process, and this is something that's really important with more and more sellers occurring over the internet. You can expect some responsibility from maybe an in-state seller knowing how some of your exemptions work. But when you have your in-state sellers that are selling to folks located outside the state, and that person is claiming an ag exemption in Utah or Colorado or, California, that's very, very difficult. But it is important that you have the seller capturing exemption information so that if a state wants to go out and audit a purchaser, they can go out and they can do that. The streamlined states have that. The non-streamlined states, some of them impose a burden on the seller for certain types of exempt sales. That makes it really, really difficult and is a catch-22 for the sellers being able to know how the ag exemptions work in all 45 sales tax states. That's next to impossible.
And I think that really gets into think about your own Kansas-based businesses, your constituents that are shipping into all these other states. 22 streamlined or 23 other states, full member states, if they get an exemption certificate at the time of the sale or within 90 days after, they in effect are off the hook. The seller can't be held responsible as long as there's no fraud, no soliciting to claim improper exemptions, things like that. But in the other 22 states that your constituents are collecting in, some of them have good faith provisions such as you need to come to our state and verify that that is actually the correct number that they put on that form. Now, if you're a remote seller and you're trying to operate 24/7, you're making online sales, who's going to do that? How are they going to be able to do that? That's what we felt that is an extremely important piece, and I'm glad Fred really stressed it as well about and then we call it not applying a good faith provision. In effect, relying on the purchaser to claim a proper exemption, and that you're not going to hold that seller responsible for it and create any liability for them.
Yeah, and really appreciate. Yeah, and Streamline just recently put a lot of work into disclosed practice that the Streamline states are providing information on what they're expecting on the exemption certificate. So that even helps states more, or businesses, I should say, more with compliance. And then, returns, tax returns can vastly differ. You had Secretary Burkhart talked about, filing 6,000 different returns. You have a very streamlined system that sellers can use in the streamlined states, a simplified electronic return, often short named as an SER, something that makes it much easier for businesses to be able to file the tax liability that they've collected and remit it to the state. And then a lot of kudos goes to the streamlined states, and they have a centralized registration system where a seller is able to register with all 23 states at the same time. Now, the states may be able to ask for additional information that they have, but a seller is able to effectively register in all the states at the same time, rather than having to independently file applications in other states. That makes it a lot easier. So you talk, and you look about undue burdens. The streamlined states have really reduced a lot of undue burdens. And Pat later on in this presentation is going to talk a little bit more about the waiver decision and undue burdens. But all these things, Streamline really addresses and has relieved some burdens. With that, Craig, I'm going to turn it back over to you, and I'm going to have to leave soon to catch a flight.
Okay, thank you, Fred. And I just want to add to it on that separate registration. It's not just about being able to make it easy to register. I think you asked the question about what about unregistering? I think it was you. If you no longer have taxable sales, and can you unregister? You can do all of that through the streamlined central registration system. So you go in and literally fill in, and I'm going to call it the minimal amount of information. We need to somehow, and the states need to be able to identify who you are. So we need an identifying number. We need a name. We don't need your firstborn like some of them ask for. We don't need 2 arms and a leg or anything like that. But we're just looking for the minimal information we need. Then you go through and you literally click a box on which states you want to register for. As the registrant, that's all that you're filling out. You have to indicate when you want to start that registration. Once we have that information, that all gets transferred electronically to all of our member states that you said you want to register in. If someone doesn't say we want to register in Kansas, Kansas isn't going to get that information because we need to protect that privacy of the individual as well, and that's very important with respect to Streamline. But if you later end up not needing a registration in one of our states, and you've registered through Streamline, you log back into your account, you uncheck the box. You uncheck the box, we get that information transferred to the state electronically. They can unregister you for sales tax purposes. You have to file a final return, but that's how easy we're trying to make it from a Streamline perspective. You change your business address and you're registered in 24 states. If they're not Streamline states, you contact all 24 states individually and have to change it. Streamline, you come in one time, you change it, we send all that information out to the states, but it's one spot for you. And we're working on some additional things in that area with respect to registrations and, again, to try to even make it easier than what we do now. So let's talk about our goals. So again, when we started, Streamline operated, we kind of had 4 goals in mind. Develop a simpler system. Wipe the slate clean. Think about what we've learned over the last 40, 50, 60 years that we've had a sales tax. If we could do this all over, what would we do different to make this, call it a national system, get everybody on the same page, at least from an administrative perspective, what things can we do to make that easier? If things can't be made easier, at least make them uniform. Uniformity in and of itself, retailers will tell us, and I can tell you they tell me regularly, that's a huge simplification in and of itself. The simplified electronic return is a prime example of that. And then, as I mentioned, state sovereignty. We have to balance state sovereignty with simplification and uniformity. We don't want to tell you what to tax and what not to tax, but we want to do it in a manner so that if a state or a seller is operating in multiple states, they at least have a good chance of voluntarily complying because that's what they're trying to do. And then use technology wherever we can to try to make it easier. And it took a couple years of monthly meetings and quarterly meetings around the country. And at the time when Streamline started, all 45 states and DC participated. The only state that didn't is your neighbor in Colorado. And the reason they didn't participate is because they had their Tabor laws. They had their home rule requirements. They knew they were not going to be able to do this. So they were not participating with Streamline from the very beginning. And again, they have adopted some of the definitions and some of the provisions in Streamline, but they are not a Streamline member. So after those couple of years, we did get the Streamline Sales and Use Tax Agreement, and we just celebrated the 20th year of the initial passage of the agreement. It was passed in 2002, didn't become effective though until 2005, and Kansas was one of the first states. That's when we had at least 10 states that represented at least 20% of the population that had passed the laws, had them in effect, and we're going to be going forward. So this is where we currently stand today, 23 full member states, 1 associate member state, and this is kind of how the map looks. The turquoise, bluish colored states, those are all of our member states. You'll see the white state, Colorado, they are again a non-participating state with us. All the other states are advisor states. We do have other states that participate with us in our state and local advisory council, which I'll talk about a little bit. And we want their input, even though they're not members. Our sellers, your sellers are still selling into those states. Everything that we can do to make it easier for them is worth it. So we want to try to keep them participating. We also are trying to put forth what we call a non-member state participation option. It's for states that can't get all the way there for membership. They can't get all the uniform definitions in for whatever reason. Political, business community doesn't want some things. They have settled law in their states. They don't want some things changed. But we are trying to get more of the non-member states to participate with us again, thinking about how we can make it easier overall for sellers. As far as the
Craig,
different.
Can I jump in for just a couple of things before you go off the map there real quick?
Sure. I'll flip back.
So I just wanted to point out for those in the room who are not familiar, there are 5 states in the U.S. that do not have a sales tax: Oregon, Delaware, Alaska, Montana, and New Hampshire. Now, Alaska does not have a sales tax at the state level, but they do have local jurisdictions that have a sales tax. So when we talk about the 23 full member states, we're talking about roughly in the 1 advisory state, we're talking about half of the states in the U.S. that are members of Streamline. Now, notably, some of the biggest states you'll see, California, Texas, New York, Florida, Illinois, are not members of Streamline. And there's a lot of speculation as to why they are not a member of Streamline, but as you could see earlier when Craig talked about one vote per state, I think some of the anecdotal feedback that I've heard over the years is that there's no way that some of those large states would want to come in when they only get one vote. So I think that's one of the many reasons, but I think the largest reason why they are not members of Streamline is simply because they haven't been told that they have to be in order to collect sales tax. Now, some of that may be changed in a future U.S. Supreme Court case, and we'll talk about that a little bit later when we talk about the Wayfair decision and its aftermath.
All right, thanks, Pat. So these are the different levels of membership that we have. We actually have states in 2 levels right now. We have our full members and we have one associate member, and the associate member is Tennessee. And again, they've passed legislation to join. They haven't met all the requirements of the agreement, but they've done enough in effect for the states to say, all right, you can come in as an associate member. They pay the dues just like every full member state does, and so they share in those costs as well. We don't have anybody that's a contingent member. That would be a state that would have passed the legislation. It's fully compliant with Streamline, but it just isn't effective at this point. They have delayed effective dates. And again, the advisor members are all of the states that aren't full members or associate members. So it's really all of the other states themselves. So how we're governed.
If I could jump in with a quick question, do you have a specific criteria for what constitutes the associate membership? Is there a certain level of compliance? Is that a number, or is it a little bit more arbitrary, being able to work with each state's tax policy?
Nope. So in the agreement itself, there's a provision on associate membership, and it says these are the requirements that you have to have. And I believe it's Rule 801 or Section 801.4 of the agreement. And that lays out what you have to do to be an associate member. Now, I will tell you, one of the things with respect to associate membership is sellers, when they come in and register, they don't have to register for associate member states. And we had it set up initially when Streamline started. If you registered in one state in Streamline, you had to register in all of them. We did make that revision to the registration system now, though, to allow sellers to pick and choose which states. But that was one of the big things with associate member states. And again, it's additional complexity that they will face if things aren't done uniformly. So
Senator Tyson.
Thank you, Mr. Chairman. Thank you again. You mentioned a non-member. How would they interact with the committee if you did create that level?
So the non-members, what they would do is they would not have votes on amendments. They would not have votes. They would be paying the dues, just like everybody else is, because they are going to get the benefits of it. And they would participate in our CSP contract. Our certified service providers, when we talk about them, they can do their services for every state, whether they're Streamline or not, okay? But sellers have to pay for those services in every one of the states that are not Streamline, with the exception of Pennsylvania. Pennsylvania has an agreement that they worked out with the CSPs where they compensate them similar to how we do. We would have them participate with us in our central registration system, but they are going to have to meet certain criteria that are required by the CSPs. They're going to have to put together like rate and jurisdiction databases. They're going to have to put together taxability matrices. They're going to have to do those things that retailers and sellers need to be able to comply with the laws. But it would end up being a contractual agreement between the governing board and that state to bring them in. Now, the governing board as a whole would be the ones who would have to say, yes, we want them in, or no, we don't, or here's the issues that we have.
Thank you, Mr. Chairman. I follow up, and I can see a lot of positives and I can see a couple of negatives on the membership. But my concern, and maybe this is Kansas's lack of proactiveness. We had another board, national board, that we had a bureaucrat, somebody from the department, voted against Kansas legislation tax policy. And so they're going and representing us on these boards and not adhering to our state law. Do you guys have anything that, to me, that is a big issue. And I appreciate, you know, we're a member and you guys are making a huge effort to help pass legislation so that we can get it passed. But you definitely are a governing board with oversight to the Kansas legislature. And so how do you balance that?
So we do have a couple things. Number one, we do have a provision in our agreement that says nothing in our agreement overrides your state laws. So if there's anything that's inconsistent, your state law controls, it's not us. I mean, it's not, we can't do anything. Now, what it can do is it can create a compliance problem for you, right? So then we say, okay, Kansas is not in compliance with provision X of the agreement. Then you'd be subject to, in effect, what we call sanctions. And we have a member state right now, Georgia. They are not in compliance with all the requirements of the agreement. So they are under sanctions right now. So what does that mean? It depends. We take a lot of it, again, from the business perspective, we want to know, is this violation something that is extreme, real severe? What do you think is reasonable for sanctions? So in Georgia's situation, they're not allowed to vote on amendments to the agreement. So they in effect count, I'm going to say they count as a no vote on every agreement amendment. And the reason for that is because our agreement says that when you're passing an amendment to the agreement, it takes 75%, 3/4 of the entire membership of the agreement to pass. Now, the exception to that is we have a specific provision where associate members, where they cannot vote on amendments to the agreement. That's one of the things that they automatically lose. But those are the things that can happen. So your law will control, but it can be a compliance issue, and depending on what the sanctions would be. But we are not going to, again, override your state's law, because we feel very confident as well that it's the state legislatures that decide what their laws are. It's not 23 members plus the member from Kansas that are sitting on the governing board that needs to decide what your law is. You folks need to do that, and then be taking into account the benefits and risks of being in compliance or not being in compliance with the agreement itself. Does that answer your question?
And Senator Tyson, if I may add, the business community very much encourages participation by legislators, not just administrators, just so we can avoid the problem that you articulated just a minute ago about having a bureaucrat make a decision for a state. So we very much encourage participation by legislators.
And we do have a certificate of compliance that gets reviewed on an annual basis. And it's where the state has completed it, and it's typically the Department of Revenue, and said, here's the provision of our law that brings us into compliance with this section. Here's the provision that's in this section. Those are all published on our website for every one of our member states, including Kansas. And it explains this is why we are in compliance. And my director of state compliance, reviews those on an annual basis, reviews all 24 states to make sure that everything they've done is still in compliance with the agreement itself. We also look very closely at any legislation that gets proposed in states. And we actually encourage, and Secretary Burkhart and some of the staff at the Department of Revenue, they will let us know when bills have been proposed. They will say, here's a bill. Do we want to just make sure it's in compliance with Streamline? We will not get involved in, do we think it's good policy, bad policy, anything like that. We will look at it strictly from the perspective of, is it compliant with the requirements of the agreement? That's all that we want to do with it. If it's not, we want to work with those legislators to say, okay, this is what you're trying to accomplish. Is there a way for us to do this that's in compliance with the agreement? Or is the agreement, I'm going to call it, so airtight that there's no way for us to do this without an amendment to the agreement? And if that's the case, then we can talk about whether or not we want to amend the agreement for those types of situations.
Greg, we also had a question from Senator Peck.
Thank you, Mr. Chairman. We have heard more than once over my tenure that, well, I'll just back up. There's been proposals for a back-to-school sales tax holiday. I've been told by staff and so forth many times that we have to follow the definitions of the streamlined sales tax because we are members. Some of the definitions or items in a back-to-school sales tax holiday do not relate to going back to school at all. So if we were to pass legislation with our own definition of what are back-to-school items that are not in agreement with the streamlined sales tax, would that take us out of compliance, or is that, or have we been misinformed? Our staff is misinterpreting. what we have to do to stay in compliance with Streamline? Can you sort of help me understand that topic?
Sure. So if we have a definition, and we do have for school supplies and those sorts of items, and you wanted to do a sales tax holiday on it, you would need to follow those definitions. Now, if there was something in that definition was creating heartburn, we would say, certainly let us know, and we would get, again, we're going to get input from the business community in particular, because, you know, they're also going to have to be the ones to try to administer it and say, can you administer it? You know, or is it going to be the clerk sitting at the register that's going to have to decide, do I tax this item or not tax that item? And that's kind of, you know, that's one of the things that we think about with respect to definitions and what's included and what isn't, and where we allow toggles and where we don't. But it sounds to me like whoever's been informing you is telling you correctly that, yes, we have a definition in the Streamlined Sales and Use Tax Agreement, and if you were going to adopt a sales tax holiday on it, you would need to follow that, you know, that particular definition. You know, I can tell you we had a state that was looking for some energy efficient sales tax holidays, energy efficient appliances. And they came to us and said, look, you don't have a definition. We'd like to do this. Can you work with us? And we worked with them. We worked with the business community, and we came up with definitions that worked, that the business community felt was administrable, that the departments of revenue said, okay, yep, we can take care of that too. You know, and I think they have to always be thinking about it when, from the department's perspectives at least, if they're going to get questions on it, are they going to be able to answer the question and say, yes, this qualifies for exemption, or no, it doesn't? So that's the clarity and the certainty that we want it. And really, again, if the business says we can figure it out, then I'm going to make a big presumption, and certainly you can say otherwise, but it would make a presumption then that the Department of Revenue could also be able to figure that out too. But that's the importance of the uniform definitions, and that's kind of why they come about. And I know, Pat, do you have anything you want to add to that from the business perspective on those definitions?
No, I think you were spot on, Craig, and that is, you know, if there is a change that needs to be made in those definitions, we would invite any legislator to come forward to streamline and see if we can make that change.
Mr. Chairman, that's more cumbersome than I would be willing to go through. For example, on this simple issue of back-to-school sales tax holiday, I don't see blankets as a back-to-school item, for example. And I'm not going to list every item. But again, so if we did pass legislation that didn't meet your definition, what would be the penalty for Kansas?
I can't answer that question. The reason I can't answer it is because it becomes the governing board as a whole, with input from the business community, to determine, okay, what's the level of severity from their perspective? What's the difficulty that it's going to cause? What's the potential liability for the businesses if they don't, you know, if they don't comply? And I know, and what I have heard over and over from the business community, for example, with exemptions, if they don't exempt something that they should, then they're subject to potential lawsuits from folks, right, for over collecting. If they do collect something that or exempt something that they shouldn't, then they're subject to, whether it's a key tam type lawsuit, or it's subject to a lawsuit or an audit by the department for them exempting something they shouldn't have. Those are the things that get weighed, but ultimately the governing board meets, the governing board votes on it, discusses it, and recommends what the sanctions would be. Like I say, I can tell you what we've done with Georgia. I mean, which is you can't vote on amendments, you can't vote on other states' compliance. Those are the things that we've prohibited them from doing it at this point in time.
That, Mr. Chairman, sort of, I believe, sheds light on why some of us have not been real supportive of the Streamline Agreement, because some of the definitions in back-to-school sales tax holiday, you ask any merchant, most merchants are going to say, no, that's not a back-to-school item. But yet, if we pass that and they don't exempt that item, then there could be some problems. Thank you, Mr. Chairman.
Representative Turner.
Thank you, Mr. Chair. Say, on your top bullet there, I'm still a little unclear on the seat on the board. So the question was asked earlier, who actually casts that one vote for Kansas? And when that question was asked, my notes, at least I captured, we've got 4 delegates, 1 senator, 1 House rep, 1 from the DOR. I didn't catch who the 4th one was, and I didn't catch how that transforms into that one vote.
It depends on your state law. So the governing board bylaws say each state can have up to 4 delegates. Your state law decides who those delegates are. Just as an example, we have a state, my home state of Wisconsin. We have one delegate. Under our law, it's only the Secretary of Revenue or his or her designee that can represent. So each state decides who they want. Once they've appointed their 4 delegates, that state in its own, I'm going to say under its own umbrella, has to decide who's going to be the one to cast that vote. And, you know, I don't know if that's something from your legislative perspective, you want to look at it and say, we're going to put these delegates in, and this is who has the deciding vote if there's disagreement. You know, I'm going to say, fortunately, in my 10 years now, almost at the department or at the governing board, we have not had that issue where one is saying yes and another one is saying no. They've been able to work it out, and however they work it out is up to, you know, I'm going to say it's going to be up to them as far as deciding who's going to cast that vote. Is that?
Yeah, thank you. So I think you're saying it's in our state law. That's where the answer to is.
The answer is in your state law as far as who represents. I don't believe your state law says this person is the one that gets priority over the others. Okay. So then we talk about the governance of our governing board itself. So again, the governing board has, each state's got 1 seat at the governing board. All of our meetings are public, unless we're talking about confidential proprietary information. Anybody can speak at those meetings. We want input. We want as broad of input as we can get. And then we have our slackers and our backers. Our slackers are our state and local advisory council. And then our backers are our business advisory council. And I'll talk about what each one of those are. We talk about the governing board. Again, I would say that's the entity that has the power within the organization. That's the entity where any amendments or any changes to the agreement have to be approved. And again, it's a very high standard. You got to have 75% of the membership agreeing with that change before it takes place. And the reason for that is we want to make sure, I mean, for us to get to 75%, there is a lot of vetting, there is a lot of discussion, and there's a lot of understanding to make sure that, okay, are we doing the right thing? And so that's why that is in there that way. They do a lot of their work through subcommittees, like certifying the certified service providers and tax technology systems. We actually have a certification subcommittee that does that. And each state sits on that as well. And I will be talking about some of those subcommittees as well. That's kind of the governing board itself. Then our state and local advisory council. This is where, and I tell you, this is the group that gets into the weeds and probably the roots of all of the issues that come up. When there's amendments to the agreement that are considered, they typically get run through Slack. These are the subject matter experts within the states, subject matter experts within the business community that come together and discuss these issues and try to develop language in an agreement or in an amendment that is agreeable by both the state side and the business community side. Again, keeping in mind administrability. Can the business administer it? Can the state administer it? We do have membership, the leadership of this is member states. They vote on who they want to lead the state and local advisory council. And right now we have Dave Metelsky, an attorney out of Michigan, that is our chairman, and Mary Hopkins out of Minnesota, they're our vice chair. And those change every couple of years. We also find that Department of Revenue employees and others that are serving as chairs, sometimes they leave their positions. And sometimes we're forced to turn those over more often than we would like to. But they're the ones that do a lot of the, I'm going to say, the behind the scenes work that go into developing what ultimately comes to the governing board for consideration. They work very closely with the Business Advisory Council. And Pat, did you want to add comments on this?
Sure. I think the slide is pretty self-explanatory. We are the Business Advisory Council is the voice of the business community. We consist of not only individual businesses, but as well as associations like us, the Council on State Taxation, as well as practitioners. Various accounting firms and law firms participate in the Business Advisory Council, as well as the certified service providers are represented on the Business Advisory Council as well. And this is kind of the voice of the business community to provide input to what the State and Local Advisory Council and ultimately the governing board is considering, just to make sure that that we try to have as many unintended consequences as possible in terms of what the governing board is considering. And I think Senator Tyson got to witness that with her involvement. I think that the State and Local Advisory Council always listens to the business community. They may not always do what we want them to do, but they always listen and do so with a very receptive voice.
And talking about how we're governed, this is kind of just a,
We had a quick question from Senator Holland.
Thank you, Mr. Chairman. Yeah, just a quick question on the Business Advisory Council slide. So you talk about the voice of the business community. How are you ensuring that balance between obviously the large corporations versus the small sole proprietors, you know, small business entities?
Sure.
How do you try to maintain a balance between that?
So the Business Advisory Council itself, any business can be a member of it, small, large, whatever they want. Businesses also don't have to be a member of the Business Advisory Council to provide input at any of our meetings. And we have practitioners from non-member states that participate in our meetings. They represent a number of very small businesses. They're small accounting firms. They will represent their clients, but anybody, any business community member can participate and provide input. And again, it's not that everybody's in agreement when we're going through all of these discussions, but it's making sure that we have all of those viewpoints. And I think, again, and somebody mentioned that Streamline focuses a lot on the small to mid-sized businesses. Those are the folks that can use the certified service providers for the most part at no additional cost in states where they're what we call a CSP compensated seller, no physical presence. Your larger businesses, they certainly see, you know, whether it's your Amazons and your Walmarts and your Targets and those folks, they've got physical presence in just about all the states, but they see the benefits of having that uniformity because they don't have to try to figure out what a definition means in one state versus in another state, for example. But we are certainly open. We have a public mailing list, email list. Anybody can sign up for it. Anybody that signs up, they're put on that mail list. And anytime we have announcements of meetings and things like that, that information automatically goes out to them.
And Craig, if I could, go ahead.
I said, go ahead, Pat.
Oh, okay. I just wanted to add a couple of things from my perspective. First of all, we do have regular participation by members of the NFIB, the National Federation of Independent Businesses. So we do have that small business voice, as well as we have a couple of practitioners who exclusively work with small businesses, and they are kind of the voice of those smaller businesses. That's point number one. Point number two is that when we are talking about simplification and uniformity, I can't think of one instance where there has been a large business versus small business issue. Now, there may have been a large business, small business issue when it comes to whether or not the U.S. Congress should have adopted one of those acts, or whether or not the Quill decision should have been overturned by Wayfair. There may be some differences there, but when it comes to simplification and uniformity, I think all businesses, whether they are large or small, want taxation to be simple and uniform, or as simple and uniform as possible.
Thank you very much.
All right, so if we look at how we're governed, this is kind of our hierarchy with all of our different committees and that listed as well. We elect a president every year. We elect a first vice president, second vice president, treasurer. So we elect our officers every year. We rotate our president between a elected official and a tax administrator every year. So one year we have a tax administrator that's the president. The next year we have an elected official that's the president. That's very important to our business community. They want that balance. They want that perspective from both the tax administrator and the legislator, which they're not always on the same page, believe it or not. But that happens. And I've had people ask me, how difficult is that sitting in the position you're in? One year you're working with a tax administrator, and the next year you're working with a legislator. What I tell them is, I'm trying to get the tax administrators and the legislators to talk as much as they can, because I think Legislators will learn a lot from the tax administrators and realize there's a lot of expertise there. At the same time, the tax administrators, and this is really where I put on my tax administrator hat when I was with Wisconsin, comes back and says, we start to understand more of the business perspectives. You know, it's not just, okay, here's what the law is, but that is what your tax administrators are forced to administer, right? What's passed is what they have to administer. And understanding what the business perspectives are of it, you know, I think that's the communication between the legislators and the tax administrators is so important. We have an executive committee. It's a 10-member executive committee in equal balance, 5 legislators and 5 tax administrators on our executive committee. All of the other committees on that bottom row, they are chaired by members of our member states, different members of our member states that will chair those committees. They will chair them for, it might be a year, it might be 5 years. Our certification committee, I will tell you, the state of Kansas, the chair of that state from the state of Kansas for our certification committee was from the time Streamline started up until 2012 or 2013, about the time that I started as the executive director. And that person chaired our certification committee for that period of time. Again, they're doing that in addition to, let's say, their normal duties. So it's kind of the over and above is what we're expecting from the Department of Revenue employees. And again, we get a great response for it. We move on to some of the key features of the agreement. Pat and Fred covered some of the things that make the systems burdensome, the sales tax systems burdensome. And you will see that a lot of the things that we have listed here, they address those areas where there were those burdens. The state level administration of local sales and use taxes, we require that. 1 audit per state. You can't have every local jurisdiction going in and auditing a company and each one coming up with a different answer and then have the state come in and maybe come up with another different answer. The state administers them, and it does not have to be the State Department of Revenue. It just needs to be a central agency, a central third party that's going to oversee it all, if that's what you want to do. Again, the Departments of Revenue, they have the expertise. And that is, I will tell you, that is what every one of our member states do, is obviously the Department of Revenue takes care of it. The common state and local tax bases, again, can't say enough. There's over 12,000 taxing jurisdictions in the United States. In Streamline, we've got about, I think it's about 4,600 of the taxing jurisdictions are in our member states. And we require the same tax base within a state at the state level and local level. If it's taxable at the state rate, it's taxable at the local rate. If it's exempt at the state, it's exempt at the local. Now, there are some exceptions, and those were exceptions that were worked through with the business community. For example, Kansas just did a reduction in your rates on food, right? So you got a second rate. That specifically was agreed to by the business community and the states early on when the agreement was developed, was to allow second rates. Motor vehicles, manufactured homes, registered and titled items, those are things that most purchasers have to go and self-report anyway. You have to register your vehicle. They can pay the tax there. They can have differences in the state and local tax bases. But when you're talking about most things that are sold, when you go in and buy a piece of clothing, if it's taxable at the state, it's taxable at the local, and vice versa. So that's what we're talking about with the state and local tax bases. The destination-based sourcing rules, we're looking at where does possession of the property transfer from the seller, seller's agent, to the purchaser, purchaser's agent. So typically, you walk into a store and you buy something, where does possession transfer? You take it right over the counter, right? That's the rate that gets applied. You have it delivered to your house, you have it collected tax based on where you took possession of it at your house. Now, there are situations where sellers may not know where possession transfers. Again, I'll ask you to think about digital products. Think about software. You don't know where that person is sitting when they download that music. And I think Kansas right now, you don't tax the digital products. Is that correct? Specified digital goods? So, but in states that do, and if you have sellers in Kansas that are remote sellers in other states, they need to understand where they need to collect that tax. So they don't do it over the counter. They don't know where it's being delivered, but they probably have the customer's address in their books and records. So they can use that as sourcing. It doesn't make it perfect, and you're not going to get it perfect. If we do try to make it perfect, the sellers are they're going to pull their hair out trying to figure this out. But if you don't have an address, it's a customer that maybe you never had before, So it's a first-time customer. For whatever reason, they don't give you an address. You don't have that in your books and records, but they give you a payment instrument. That payment instrument's got an address. Then you can use that as the address, and you can source to there. And last but not least, if you don't have any of that information, and again, the reason for this last provision was to make sure that sellers knew that if they collected tax following this hierarchy, that they would not be held liable for additional tax. And that means it gets sourced back to what we call origin, the location from which the seller shipped the product or the location from which the product was first available for transmission in the case of digital goods. So again, it's trying to address those types of things. Now, Kansas was an origin-based state, right? You taxed based on where the seller was shipping the product from. Now, if you did that on a nationwide basis and you made origin-based sourcing, and this was something that was considered early on, you're going to have, and Pat talked about the nomad states, and I refer to them as the nomad states. It stands for the New Hampshire, Oregon, Montana, Alaska, and Delaware, right? The nomad. Other people have come up with other acronyms, but I'll stay with nomad. People all of a sudden are going to be locating their warehouses where? In those states. No sales tax if you go to origin-based sourcing. Now, within a state, you can still have origin-based sourcing. And initially, the agreement prohibited that. Now we allow states to do that. But if you're doing it, what you're doing is you're telling your sellers, you have to run two systems. An origin-based system, if you're shipping something from within the state of Kansas to another location within Kansas, then you use where it's shipped from. But if you're shipping from Kansas into any other location outside the state, there you have to use destination. So it puts additional burdens. In effect, they have to run two different systems to be able to determine origin versus destination.
And Craig, if I could jump in there just to clarify one thing real quickly, even in a pre-streamlined environment, I can't think of one state that had origin sourcing for interstate sales. Several states had origin sourcing for intrastate sales only, or sales from one point in the state to another point in the state. But I think there are constitutional problems if you have origin-based sourcing for interstate sales. And so I just wanted to make that clarification. Even in a pre-streamlined environment, we didn't see that.
Sure. Thanks, Pat. Our central registration system, I think we've touched on that. Again, I don't know if I want to get it, don't need to get into any more details with that, other than the fact saying it's there, it's free. Sellers do not pay anything to register through the central registration system. I would encourage you to go in and look at all the different states' registration applications if you've never done this, and look at them. They range from one page up to 20 to 25 pages long just to get registered so that they can collect and remit a state's tax. We had a former tax administrator that left the Department of Revenue in Oklahoma, or Oklahoma Tax Commission, went to work for a law firm. One of his first requirements was he needed to go and register a client, and I can't remember, it was like 33 or 36 states. It was all the streamlined states plus some additional ones. He said, I did all the streamlined states. It took me about a half an hour. He said, it's taken me weeks to work through all of the different applications and the different requirements that the states have for the states that aren't streamlined. And he said, I never realized that when I was a tax administrator in Oklahoma, how much of a benefit that was. I just thought it was, okay, so they can do a quick application, not a big deal. But he said, when you actually have to go out and do it in real life, he said it makes a huge difference. So that is something, again, we're very proud of it. We continue to make changes to it, updates to it, as we find additional issues that sellers have with it or concerns that people have. Uniform definitions are mentioned in there again. This is just a list of some of the uniform definitions that are out there. I will tell you that every product that is uniformly defined in the agreement, every one of our member states has to indicate the tax treatment of that on their taxability matrix. And they have to keep that up to date. And again, these are just some samples of them. Again, some of you may have heard about some of our definitions and that they create some oddities. Anybody talk about the definition of candy? That's usually the one that everybody pokes fun of us at. And the reason for it is we use a flour standard, right? And the question is why? The business community was looking for clarity and certainty, right? So they said, what is the bright line? They did not want a subjective test. If I ask one of you what's candy and I ask somebody else, you agree that everything that person says candy is candy? May or may not be. So now, that's even within just, I'm going to say within this small group, right? Now expanded out to 45 states. Imagine the subjectivity. So what the business community came up with, and actually it was with the business community, was saying, what can we use as a bright line test? And the bright line test was flour. Yes, that results in the Twix bar not being considered candy, but the Snicker bar is candy. And again, you get some oddities, but you get clarity and you get certainty. And you don't have to worry about, and Secretary Burkhart and his staff don't have to try to interpret what's considered candy. Are candied yams candy? They have candy right in the name. No, right? But those are the questions that you run into, and those are the things we try to address with the business community.
We have a question from Senator Tyson.
Thank you, Mr. Chairman. Thank you again. And I just wanted to bring to this group's attention that you will be discussing candy at your next meeting, the definition of. And licorice is not included in candy because it contains flour. So, and the committee probably is very much aware with the food definitions that we were arrived at in legislation last year, it was to keep us in compliant with streamlined sales tax. So thank you, Mr. Chairman.
Sure, yeah, and on like definitions like food, and I think Pat touched on too, we have different toggles. You can exempt food, but exclude from that definition candy, soft drinks, dietary supplements, things like that. Each state has that choice. I mean, those are different toggles that are there. Does it create differences from state to state? Absolutely. But it creates differences that can be programmed. As long as you have call it a finite set of products in the sense that it's a clearly defined term and you're saying, we're pulling this out of the definition, businesses, our software providers, they can program that into their system as far as what's taxable and what's not. It's when you don't have clear definitions. And that's really when I'm looking at toggles from my perspective as the executive director. I'm trying to give states maximum flexibility, but I'm trying to make sure that business can administer it. And that's really, again, that gets into that balance. And those are things that I'm sure you're going to hear too, is if you bring different proposals forward, they're going to say, yes, this works, or no, this doesn't work, or how do you expect us to do this? So I would ask you to keep those things in mind.
And Craig, if I could jump in on that one real quick, I mean, from the business community standpoint, it's all about administrability. So Craig talked a little bit earlier about the balancing of state sovereignty versus uniformity. And he said very clearly that the state does not have to tax all of these products the same way. But if you have the same definition of what these products are, then it makes it much easier for businesses, including the small businesses that are out there, to differentiate as to what they should and should not tax.
And this is a list of some of the additional simplification and uniformity provisions contained in the agreement. And again, we've touched on many of these, and we were talking about what are the things that make a system burdensome. And these are all things that have been addressed in the streamlined sales and use tax agreement. I would talk a little bit about liability relief provisions, because this was one that I can tell you, coming from Wisconsin and having my administrator hat on, I thought every state did it the same way that Wisconsin did, which was if I put something out in writing and I tell a seller what to do and they do it, I can't come back 2 or 3 years later and say, that wasn't right. You should have done it this way. And all of a sudden they have some liability. We put provisions in the agreement. So everything that's in the state's rate and boundary databases, that's in their taxability matrix, where they've said to businesses, this is what you tax, this is what you don't tax. There's liability relief. If the sellers rely on that information and it's wrong, they can be told you have to correct it, but you're going to correct it prospectively. You're not going to be held liable for back liability. And then obviously that last bullet down there is our certified service providers. And I do want to, and I know I'm not sure, Mr. Chairman, how long you were planning to go. Like I said, I could go for days, but would like to talk about the certified service providers and, what exactly they are, because that is a question, because there is a cost associated with that from the state perspective. So when you think about a certified service provider, think about a third party that outsources its sales tax requirements. Companies have been doing this for years with what? Payroll taxes. right? They've had third parties that come in and handle all their payroll tax liabilities, file the returns, do the calculations. I'll tell you, the governing board has it. We have a company that takes care of that for us. I don't want to have that responsibility. Now our certified service providers can do that exact same thing with sales tax. So they in effect step into the shoes of the seller. They're going to integrate their system with the seller's system so that when a transaction runs through it, it does these things. It determines the taxability. It determines what the state and local rates are. So there's going to be information that the purchaser puts in there. They're going to know how much tax is due to each jurisdiction. They actually prepare and file the returns for all the jurisdictions within our member states. They make the required remittances, and then it says meets any other requirements that are set by the governing board, which means we have a contract with them, and there are certain things that they need to do. They have to post a bond with us. They have to, we need to make sure that we are secure with them. They have to go through an annual or a 3-year contract compliance audit where we go through and we dig into their system and we make sure it's still operating correctly. All of our member states on a quarterly basis test their system. We have a test deck of transactions that they have to run. They have to come back and say, here's what we determined. We determined this much was taxable, this much was exempt, here's what the rates were, here's what the jurisdictions are, and make sure it matches what the state's expectations are. And we're doing that quarterly to make sure that these folks keep their systems up to date, make sure that they continue to accurately calculate the tax that's due. Before they can ever become a certified service provider, every one of our member states, Kansas and all the 23 other states, reviewed their taxability rules, where they went through and said, here's a code that says clothing. For Kansas, it's taxable, or for Minnesota, it's not taxable. Every state went through and reviewed their own state's rules to make sure that it calculated the tax or had the right tax determinations. If one state said, nope, it's not right for us, we didn't sign a contract with them. We needed every state to agree to it. So instead of one state saying, okay, yep, we're good to go, we needed 24 all at once to say we're good to go. That took some time. As these certified service providers add additional customers, they're adding their certified categories. They send those to us. We send them out to our member states and say, okay, now they also have a company that is selling X medical products. And here's how those are treated. We're going to send it to Kansas. We're going to send it to all the other member states and say, do they have the treatment right for you? And the certified service providers want it correct because if it's wrong, they are on the hook for that tax. If they say something is exempt and it should have been taxed and the state told them, nope, you should have taxed it, or they failed to send it to the state for certification, the states will hold them liable. Not the seller that's using their system, it's going to be them. And that's a huge benefit to the sellers that are using those certified service providers. And sellers that are using these CSPs, it's not just in states where they don't have physical presence. The numbers that Secretary Burkhart has, the numbers that we have are all based on, in effect, remote sellers or what we call CSP compensated sellers. But there is a multitude of sellers that are using these same certified service providers and reporting tax to Kansas, and they are paying the certified service providers because they're not a remote seller in Kansas. They have a physical presence. But you still get the benefit of knowing they used a certified system. So instead of having to go to each one of these sellers individually and look at what their tax rules were, you look at the certified service provider's tax rules, you confirm that they're correct, you've covered that whole population of sellers that are using them. Now, one caveat to that is each of those sellers has got their own individual products. They put them into the certified categories. And that is the function and one of the things that our contract compliance audits and our state audits do is to make sure the seller took the time to make sure they put the computers in the computer bucket as opposed to putting a computer in a clothing bucket. They don't know what the taxability is of those buckets for all the states. The sellers don't, but the CSPs do. And all they know is that anything that goes in the clothing bucket is going to be taxed for these states and it's going to be exempt for these states. The computer bucket's the same way. So That's how their process works, and it's that mapping piece is the one piece that we are continuing to work on with the CSPs, and we certainly encourage our states to look at as well. Now, there are benefits. Go ahead.
Just had a quick question, reiterate the question I had earlier. If I'm a business and I'm looking at contracting with a CSP, are there quite a few of these out there? Are there choices for people, or is it kind of a monopoly?
So right now, we have 5 companies that are certified service providers. We have had a number of companies come to us and say, we want to become a CSP, and we start looking at their system, it's not going to pass muster. And we don't want them associated with Streamline, because we start certifying companies, I'm going to say haphazardly, and all of a sudden you've got companies that their tax calculators are wrong, states are going in and making assessments, customers are realizing they're either being over or under collected, undercharged the sales tax. That's not a good look for Streamline. And we just don't want to, I'm going to say, be a part of that. We want to hold them to a very high standard, and they know it. And that's part of the reason too, why when you start talking about compensation, it's okay, sometimes you're going to get what you pay for. And, we could get a number of companies to do this, and there's a number of companies, and there have been some that have tried to say, oh yeah, we follow Streamline and we're part of Streamline. And I've had to reach out to them and say, pull it right now, or our attorneys will have to be in touch, because we do not want people associating with Streamline if they're not doing the right thing. So, no, it's a small number. I can tell you that we've got a couple of companies right now that are in the process where we've started talking with them. They want to become a CSP, but it's a very rigorous process for them to go through, and it's intentional and it's time consuming. But when we're done, we know we're going to have a quality product, and that's really what we're looking for.
Well, and I think the main advantage to the seller is it's at no cost to them, but I'm sure as a seller, as a business, I would want to make sure that the CSP that I was contracting with was in good standing with Streamline and their systems.
Yeah, and we will get calls from sellers saying, hey, I used this CSP and they got this tax wrong, and my customer brought it to my attention. And that calls into question the whole thing. Well, then you start looking into, okay, why did it happen? And many times there's a reason for it. I mean, we can explain, okay, this is how this happened, with this state or this state, or this rate and jurisdiction database, for whatever reason. The states, they're not always right with their rate and jurisdiction databases, and ends up with an incorrect tax. And I have to say, it's amazing the number of people that actually do, and maybe just because I've always been in sales tax, and it's been one of those things where I always kind of look at my invoice and I see the tax, and even once in a while when I go to Walmart, I'll go through and, oh, they taxed this and this, but they didn't tax this. Okay, yep, everything looks good. But it's amazing the number of people that do that. And it seems like it's, even if it's a couple pennies here or there that are off, those are the things that raise more of a question than anything. And businesses want to get it right, because if they overcollect, they end up facing the class action lawsuits. If they undercollect, KETAM lawsuits, they potentially end up with the Departments of Revenue coming to visit them. So it's encouraging for them to get the tax correct. And there's also, with the CSPs, there is zero incentive for them to not collect tax when it's due. Why? Because that's how they're paid. They get a percentage, 2 to 5% of the tax that they actually collect and remit to the state. That's what they get as their compensation. And again, it's based on the amount of tax that they collect. It's 5% of the first 500,000, then it drops down to 2% of the amount after that. There is a provision for very small sellers where they can get 6% on the first $8,000 of tax as well. But that's how they're compensated. So again, there's no incentive for them not to do it right, and to not be collecting the tax that's legally due and owing as well. And again, the benefits to the states, you get an upfront review of their tax rules. The Department of Revenue reviews their tax rules. And we'll tell you right now, we have over 20,000 sellers registered through Streamline. Are they all registered in Kansas? Nope. Are they all registered in every state? Nope. But there's, I think Kansas, I think your number was roughly 9,000 of volunteer sellers that are in there right now. But they review those tax rules, and for those sellers that are using CSPs, they know that they're getting that, or the likelihood of them getting the accurate tax, the correct tax, is much higher. And they get, for all, let's just say that out of that 9,000, let's just say 7,000 of them were using CSPs. That's, instead of doing 7,000 audits to check that out, they check out one. They check out the CSP, and it covers all of those sellers. You get the timely electronic filing. I know Secretary Burkhart touched on that, the importance of the electronic filing of the returns. They're timely filed. If they don't file the returns timely, they don't get the compensation. They don't qualify for it. So that's a requirement in there. The ongoing testing I mentioned. And again, no cost unless they actually remit tax. So for those sellers that they're processing returns and there's no tax due, they're not getting compensated by any of the streamlined states either. For the sellers themselves, again, it's the no cost is the big piece. Wherever you're a CSP compensated seller, for any of our member states, those are the ones where you qualify and the state allows that compensation. The seller, what they do is they make one payment to the certified service provider for all the tax they owe in all the streamlined states at one time. Once a month, those returns are filed. The CSP calculates it, the CSP sends it to them, verifies it, they do whatever verification they want on their end. They send the money to the CSP. The CSP then prepares the return and files it with all the different taxing jurisdictions that the returns need to be filed with, and makes the payments to those jurisdictions. And again, that's all done electronically as well. And then if there is a problem with it, again, the CSP is the one that's on the hook for it. If their system is not operating properly, they are the ones that are on the hook for it. If it's a matter of the seller failed to give them accurate information, true information, yes, there are situations where then that liability can get pushed back to the seller. So that seller that says, I'm selling clothing, but they're really selling computers, and they're shipping it into the state of Minnesota that exempts clothing, so all of a sudden that computer didn't get taxed, Minnesota finds it, Minnesota's been assessed that tax, and likely the CSP is going to go back to that seller and say, you can't put a computer in the clothing bucket. And that's the reason why there wasn't tax collected. So those types of situations. And again, we did audits, so we'll be coming up on a year where we're going to be doing our contract compliance audits and our state tax compliance audits. And when we did our last cycle of audits, I will tell you that there was less than $25,000 nationwide assessed to sellers using certified service providers. And that's for a 3-year period. That's all of our member states. They participated in the audits, and they can choose to participate or not participate. That's entirely up to them. But again, I think that shows the accuracy of the systems that the CSPs have and that the sellers that are using them, the benefits that they get, knowing that the amount of tax that they're calculating, collecting, and remitting is correct. And again, that's about the only way that we know that we can show that this is, in an after-the-fact situation where you come in and look at transactions and do audits. This is the way we're able to show that the accuracy of those systems. This is kind of what a CSP compensated seller is. So these are really the criteria that they have to meet to qualify for the free CSP services, or what I deem free CSP services in our member states. Oops. And the reality is most sellers operate in streamlined states and non-streamlined states. Our certified service providers, they can handle this in all the states, whether they're streamlined or not streamlined. But the sellers are paying for it in all of the non-streamlined states. Again, the one exception being Pennsylvania, who in effect patterned a contract with them after ours, so that they allow sellers to also receive CSP compensation.
This might be getting into the weeds a little bit, but how does the CSP handle the different definitions? If that computer bucket or that clothing bucket is defined differently to where that state isn't a streamlined member, is that just on the CSP to make sure that that definition is accurate for that state?
That's exactly right, and that's the importance of it. But that also is why when they're doing this, the costs to do it for some of these states go way up because of the research and trying to stay on top of what's taxable, what's exempt, what falls within a definition and what doesn't. But yeah, that goes to the CSPs, and then it becomes, what is the contract between the CSP and those other states and the seller? Who's going to really be held responsible for it? For example, in streamlined states, and let's just use clothing since it's an easy one, let's just say, so streamlined states either tax or exempt clothing, let's assume no toggles. But if you have a non-streamlined state that says, we don't tax red shirts, the CSP has to have their system set up to say red shirts. Now, for streamlined states, just answer the clothing question, right? And you get the answer. Non-streamlined states, they're going to have to know which states don't tax red shirts, and they're going to have to program that separately for it. But again, you can see the problem that creates for a seller. Now they have to break that out, especially a remote seller, if they're shipping into that other state that doesn't tax red shirts and they want call it the favorable tax treatment. So. Okay, so Streamline goes about, they develop the agreement, come up with simplifications, uniformities.
I just want to interrupt you right quick. We've got 3 more bullet points. We've kind of hit our lunch hour time.
Okay,
Are you and Pat still available if we would break now and come back for lunch, or would that cause scheduling problems for you?
I would be available. I need to be back to Kansas City about 4 o'clock.
Okay.
So,
Well, I don't want
I
to
am
rush through
available.
this. You are too, Pat?
Yes.
Okay. Committee, I think would, rather, our tummies would probably be happier if we went ahead and broke for lunch and would come back at 1:15 to wrap up.
okay,
I want to make sure, I know that's sometimes the danger of taking questions as we go through the process. It does draw this out a little bit, but there's been really good information, and I don't want to rush any of this final information either.
okay.
So if this is a good stopping point,
This would be fine, and we can pick up with federal legislation and the Wayfair decision right after lunch, and perfect.
well, if that's agreeable to the committee, we'll go ahead and recess until 1:15. Well, committee, I think we're back and ready to get started after our lunch break, and we will pick right up where we left off with Mr. Johnson. I'm sure, Pat, or have you joined us again?
I am here if you can hear me.
Okay, yes, loud and clear. I'll go ahead and turn it back to you, Craig. Is your microphone on? You might.
There we go. Is that better?
There we go.
Okay.
Yes, thank you.
So I think where we left off was with the federal legislation, and it was just to kind of touch base and let you kind of know that this is what we tried to do. And I think Pat or Fred, when they talked about, different ways that we can try to get streamline implemented, it was try to get Congress to do something or potential litigation. And just to give you a little bit of an idea as far as the way the federal legislation goes, once we had the agreement in place, we went through and we worked with Congress, and I can tell you that I spent a significant amount of time up there, and a lot of the time in Washington, D.C. that we spent talking with folks in Congress, I spent with one of your folks from, formerly from Kansas still, and that was Joan Wagner. She used to be a governing board president from Streamline very early on in the process. But there were a number of bills, and this is a list of all of the different bills that that were introduced, and they were introduced multiple times in Congress. And only one of those bills ever got a vote, and it was the Marketplace Fairness Act. The vote was 69 to 27 in the Senate, went over to the House, and it just died. And it was because Chairman Goodlatte at the time had completely different ideas on how he would like to approach this, and so that never went forward in Congress. So that's what's happened. Now, in a post-Wayfair world, there have been some bills introduced, but the bills have been to try to stop the states from being able to require remote sellers to collect tax. So that's something that we are keeping a very close eye on. We do have boots on the ground in Washington, D.C., watching these things for us, working obviously very close with the business community. And it's interesting, the folks that were really against federal legislation previously now are the ones that are, I'm going to say, reaching out to Congress in many cases and saying, you need to do something. Now you need to do something. And it happens to be those businesses that many of them were just selling online and they knew they had a competitive advantage. Now that that's gone, that competitive advantage, now they're looking for Congress to do something. So that's kind of all we want to really say about the federal legislation. But what that really did, after those years that we tried to work with Congress on it and worked on proposals, it really led to the state frustration. And that's really what pushed us into the Wayfair decision. And I just want to make a comment that the reason South Dakota, we ended up there, Senator Deb Peters, who shepherded the bill through the state of South Dakota legislature, she was a former governing board president. She was president of the governing board in 2015. She was also National Conference of State Legislatures president in 2016. We worked very closely with them, and Pat and Fred were both involved in it as well, but drafting legislation that would allow the state to, in effect, challenge the Quill decision. And that was the recognition. Was this legislation was not something that the state was just going to be able to say, hey, this is what we're going to do, and it just automatically became effective. It was going to have to be litigated because it really flew in the face of Quill because it threw physical presence out. But we threw it out saying, we believe we've removed the undue burdens. That was the kind of the genesis or the premise behind it. So, Pat, did you want to jump in on this then?
Sure. And if there's kind of one thing I wanted to leave you with or be clear you understood, it's this, the Wayfair decision and what it held, and probably more importantly, what it did not hold. Because we hear this case mischaracterized all the time. And we hear it mischaracterized as the Supreme Court held that South Dakota's law was constitutional. It did not. All it did was it got rid of that physical presence test from Quill and, as Secretary Burkhart said, National Bellis Hess. And it specifically stated that, look, we could potentially find South Dakota's law to be unconstitutional under a whole host of this court's Commerce Clause jurisprudence. But none of those issues were litigated, briefed, or before the court. So the court remanded that case back to South Dakota. But then it said in what's referred to as dicta by lawyers, it said that having said that, We think that there are three features of South Dakota's law that mitigate the burdens on interstate commerce and the discrimination against interstate commerce. And those features are, and I said that Secretary Burkhart covered these earlier, that there was a small business safe harbor, no retroactive application, and that South Dakota was a member in the streamlined sales and use tax agreement. So what does that leave us with at the end of the day? Since this was dicta, it cannot be interpreted that the U.S. Supreme Court instituted a new test. But at the same time, I think they may have been giving some guidance. And we know when the case was remanded back to South Dakota, that it was eventually settled, so we didn't get any clear indication of what a new constitutional test may be. But the U.S. Supreme Court was very deliberate in what it said, and it referred to a lot of the streamlined definitions and processes. And I'm sorry, was there a question there? I got a little feedback.
No, I think that was perhaps a different
Okay, sorry.
user that wasn't muted. Yeah, please continue.
As to what would be the new constitutional test absent that physical presence test. But it did give a little bit of guidance there. Unfortunately, given that guidance, we would have expected to see more states join Streamline, but they have not. And the question remains, should they? Now, if I was sitting in your shoes, I would take a great amount of solace that Kansas has adopted Streamline and is a member of Streamline, so that if either Congress decides to act or the U.S. Supreme Court ultimately revisits this and comes up with a new test, and assuming they were thinking the same way they did when they wrote that Wayfair dicta, that Kansas is sitting in a pretty good spot. The other thing that I would mention as to why I think Kansas is sitting in a pretty good spot is that and there have been no published studies about this, but we hear anecdotes all of the time, similar to what one of the members of the committee mentioned earlier. It was hard for me to see which one, that they're very close to the Colorado line, and some small sellers are weighing the cost of compliance with the risk of getting caught. And I think that's happening across the country. And we've heard this in some Senate testimony on Capitol Hill with respect to small sellers. And the question is, I'd be interested to see how many of sellers that are on the Colorado side of that state line are actively weighing the same risks with Kansas, since it is much easier to register and collect tax in Kansas than it is to register and collect tax in Colorado. So I would suspect that these small sellers are not an isolated incident, and that sellers across the country are weighing this cost of compliance with the risk of getting caught. And I would suspect that that streamlined states are getting more revenue from those small sellers than non-streamlined states, but we have not seen a study yet to back that up.
Pat, we do have a question from Senator Tyson, if you can.
Sure.
Field that, please.
Thank you, Mr. Chairman. Thank you, Pat. I am curious, on one of the bullets, it says South Dakota's 100,000 was the threshold that was held up, but then up above, it says that it is a substantial nexus. So would you consider $100,000 a substantial nexus? To me, that is a subjective term, substantial.
It is absolutely subjective. And when we say substantial nexus with the taxing state, that is articulating the Commerce Clause test from another U.S. Supreme Court case of complete auto transit versus Brady. And without getting too much in the weeds on it, when the U.S. Supreme Court in Wayfair issued that decision that overturned that physical presence standard. They were just talking about one of the prongs of that complete auto 4-prong test. And that's why they said that, look, there can be a whole host of other reasons under the court's Commerce Clause jurisprudence why South Dakota's law could be declared unconstitutional. But you're right, substantial is a subjective term, and prior to the Wayfair decision, it was equated with physical presence. Now that the physical presence standard is gone, we have a much more nebulous concept of what constitutes substantial nexus.
And this list of items from South Dakota versus Wayfair and the guidance, these were things, the Supreme Court listed these out specifically in its opinion. So they specifically looked at what the agreement had done. And we filed an amicus brief on this as well in support of South Dakota, because we really felt we were supporting all of our member states when we did this to get that collection authority. But for them to actually take the time to put that in their opinion, when they could have just said, there could be something else under the Commerce Clause that throws it out and ended it, because knew they were remanding it back to South Dakota to determine whether or not the whole, these other provisions such as undue burdens, whether or not they were a concern. But they took the time to point these out and saying these are things that I think from my perspective, these are the things that were very important to them in showing that South Dakota's law didn't intend to discriminate against or impose undue burdens on interstate commerce. So then that brings us to the economic nexus and remote sellers, and that really gets into all of the different states. After June 21st, 2018, when Wayfair comes out, in a couple of years, all the states, Missouri is the very last state, it's effective January 1st of 2023, to put in an economic nexus threshold. The unfortunate part is when the states did this, they put them in and they varied. They weren't consistent. It's not just the dollar amounts. It's not just the number of transactions that is a problem or that creates the variance. It's whether you said it's $100,000 in gross sales or $100,000 in retail sales or $100,000 in taxable sales. That's just an example of the things that businesses are now being faced with and they're being challenged with to decide when do I need to collect in the various states? When have I met their thresholds? There was also this number of transactions issue as well that got into the 200 transactions. If you exceeded 200 transactions in a state, you had to collect tax. Sounds great, right? And it seems like a lot of transactions into a state. Think if you're selling t-shirts, 20 bucks a pop, $4,000 in sales, and all of a sudden now I've got substantial nexus. So one of the things that Streamline is working on, and we're going to talk a little bit about the GAO report, one of the things that Streamline is going to be working on is working with our states, and I think Kansas, you're in a good spot. You guys, I think, either eliminated or never put in the 200 transactions. So you're in a good spot, but that's something that we're going to recommend all the member states do, and actually all the states, even that aren't members, to eliminate that because of that potential issue. But we still do have the question of what should it be based on? What should the $100,000 be based on, or what should the $250,000, whatever that number needs to be? Should it be gross, retail, or taxable? If you do gross, there's arguments against that because now all of a sudden you've got sellers that have $300,000 in gross receipts, but 195 or 295,000 of them are exempt. So you've got 5,000 of taxable receipts, and now you got a return that only has to report tax on $5,000. Do you want that? I mean, there's a cost to processing that return and the cost of the seller. Or you can say the opposite end of the spectrum is say, well, why don't you just base it on taxable sales? Well, if you base it on taxable sales, you're forcing the businesses to make decisions on whether something's taxable or not. So they have to understand the law before they've ever even reached the threshold. Otherwise, how can they know when they've exceeded $100,000 of taxable sales? We think a good middle ground, and again, it'll be subject to debate and discussion and vetting and everything else, is probably using something like retail sales. So you take out all of your wholesale transactions, because those are numbers that businesses can probably get to relatively easy, and then use that as the threshold. But we're going to be working on that. I mean, that's something that we see as a possibility. And this map, what this really does in the colors, it shows all those different colors represent different thresholds that different states have done. And you can see that that's what a business has to deal with if they're selling throughout the entire country. You know, some are 100,000, some are $100,000, 200 transactions. Some say 100,000 and 200 transactions. Some say 100,000 or 200 transactions. Sellers have to understand all those little nuances right now. So I do think that that is an area that we can certainly work on as far as creating some additional simplification, some additional uniformity. And again, I think we're going to really want a lot of input from the states. We're going to want a lot of input from the business community on what they think is the best and the most reasonable there. Now, Pat, did you have anything to add on that?
No, Craig, but I failed to ask earlier, and you may have already asked this before we came on to the webcast here, but I'm curious as to how much time we have left. I certainly don't want to overstay our welcome and make sure that the committee is well informed.
No, we're just very, very happy that you both are with us today, and we'll take as much time as we need to. That's why I wanted to break for lunch and come back rather than try to rush through it before lunch.
Okay, great. But no, Craig, I didn't have anything to add to what you just said.
Okay, so this next group of slides really walks through after a post-Wayfair world. And again, you know, we talked about the different thresholds. This kind of walks through some of the differences in the thresholds and what are some of the burdens that it puts on the businesses, and really takes time away from them being able to run their business, and then instead having to try to figure out, well, do I have to collect tax or don't I have to collect tax? You know, and from our perspective, the less time they can spend figuring out what they need to collect or if they need to collect, and the more time they can spend growing their business, the better off I think we all are. I mean, I think that's really what, you know, what our objective is and our goal is. I talked about the thresholds. I talked about the gross versus retail versus taxable sales. And again, I think that we need to figure out a way to come to a consensus amongst the states on what do we think is the best. This is an area that I can tell you there was discussion on in the GAO report, and the need for some uniformity in this area. And we'll talk a little bit about that. Pat, do you want to talk about the litigation on the undue burdens that are pending right now?
Sure, and we talked about this before, but in a post-Wayfair world, we still don't have a lot of clarity as to how much burden would be too much burden under the Constitution's Dormant Commerce Clause. But that issue has come to a head in Louisiana and Colorado, who are both experiencing litigation challenging the constitutionality of their tax system. Now, Louisiana and Colorado, both non-streamlined states, both of them have local administration of tax by various localities. And it's interesting because we work a lot with these jurisdictions. And if you talk to the folks in a particular parish in Louisiana, they will say, well, we don't think our particular system is burdensome, right? But it's that type of mentality. Well, your system may not be burdensome if you look at solely your system, but if all of a sudden a small seller in Kansas has to deal with not just Louisiana State, but has to deal with 50 some parishes and them all having different definitions, all having being different auditors and different filing requirements. If you put that into context with the rest of the states, and not just dealing with Colorado State, but also dealing with each individual city and county in Colorado that administers their own sales tax, all of a sudden you have a very burdensome system very quickly. So we are watching these two cases very closely, and we think that is the litigation risk that you're not facing in Kansas by being a member of Streamline.
And we're not so sure, you know, depending on what happens with these cases, you know, then what is the question? What is the next step? So if let's just say that these are found to both be burdensome. Okay, so we know that that's a problem, but this other state does this. Does that still create undue burden? We don't know. You know, there's nothing that says, and in the Commerce Clause, it doesn't say there can be no burden. Just having to calculate tax is going to be some burden. But we got to look at what is an undue burden. And unfortunately, there's no clear list of this, and this is undue burden, and this isn't. And that's really what we're dealing with and what we're trying to work through. But as you can see, I mean, we rely very heavily on the business community to be able to tell us this is why it's a burden. I mean, again, making sure that we understand that as well, and making sure tax administrators understand that and legislators understand it, to try to figure out, okay, what can we do to help remove some of those burdens. So these are just some ideas as far as what states should do. But one of the biggest things that I hear from the business community is publish clear, accessible guidance. And I'm going to say the last 15 or so pages of this presentation is information that we put together from a streamlined perspective. Covers all of our member states. In some cases, it covers our non-member states as well, because again, we felt that to help sellers to the best of our ability, whether they're a member or not, we should give those sellers a spot that they can look in one area to say, okay, what are the economic nexus requirements for every one of our states? So we took the time and did that. If you didn't do that, all those questions would be coming to, whether it's the Kansas Department of Revenue or the Wisconsin or Minnesota, or what, all of those departments of revenue would have to do it themselves. But instead, we're able to put it all together, have them review it, and we develop it and keep it there. And it's free on our website. We want as many people to look at it as possible. So certainly encourage you to do that. But I think that one of the messages we also need to keep in mind is Congress could still act. I will tell you that we still have contact with Congress, with members of Congress. There are still members of Congress, I would say, that have an interest, especially in non-sales tax states, in trying to find a way to either put up sideboards or roll back the state's requirements or ability to require remote sellers to collect tax. And that's something that we're concerned with. I was contacted last summer and asked to testify at the Senate Finance Committee. They held a hearing strictly on the implementation of Wayfair and how it's going. We had 5 witnesses: the Government Accountability Office, 2 small businesses, one from New Hampshire, non-sales tax state, one from Montana, non-sales tax state, myself, and a tax practitioner that's been involved with streamlined and non-streamlined states. So we were asked to testify, and if you haven't had the opportunity to testify in Congress, I would have been thrown out after 5 minutes, because that's what you're given. That's how much time you're given to try to get your point across, and then it's a matter of questions. Our goal with it from a streamlined perspective was we laid out everything that we did. We wanted the Senate Finance Committee to understand that in our written testimony, and then obviously we're going to get followed up questions. And our concern was, or our question was, do they think we've done enough? Do they think we have done too much? Where should we go from here? And we were very pleased. I mean, there were no challenges to what Streamline has done or has not done. There were a number of issues raised by the small businesses. Well, it's difficult to register. Streamline's addressed that. It's difficult to figure out the rates. Streamline's addressed that. We've got our rate and jurisdiction databases. Most of the questions that they were asking were things that Streamline has addressed. So we've got those answers out there. But those are good for 24 states right now, for our member states only. Doesn't help them in the other states. And the fact that they're based in non-sales tax states doesn't throw them out from qualifying. They still qualify in all of our member states, because again, they're collecting our member states' tax. So I do think that there is going to be some additional follow-up. We have been following up with some of the members, and for those of you that aren't familiar, Ron Wyden chairs the Senate Finance Committee from Oregon, which is a non-sales tax state. Senator Maggie Hassan from New Hampshire is on that committee, another non-sales tax state, and Senator Steve Daines from Montana is on there, another non-sales tax state. So they do have a number of members that are on there that are from non-sales tax states that have concern, and they are the committee of jurisdiction on the Senate side. On the House side, it's the House Judiciary Committee that has the oversight on this, and we're going to continue to work with them if they decide to start bringing proposals forward and just trying to find out what works and what doesn't. But I will tell you that during that hearing, the practitioner that works in both streamlined and non-streamlined states spoke favorably about Streamline and working with the streamlined states. Her issues primarily were in non-streamlined states. And the other issues that the businesses raised, They were in both streamlined and non-streamlined states, but they were related to the economic nexus thresholds and the lack of uniformity. So I really see that, I think, in our organization sees that as an opportunity to create some additional uniformity to help businesses in that area. And I expect that that is something that we will do moving forward. So in addition to that, Congress, some of the members of Congress also asked the Government Accountability Office to do a report, and they wanted the report on implementation of Wayfair. They wanted to know about, what were the costs that were related? What does the sales tax landscape look like now for remote sellers that are selling everywhere in the country? How many businesses does this affect? And that's a question nobody really knows. But what I can tell you is if you look at some of the reports on people that are selling on marketplaces, there are reports that there are 1.5 million to 2 million sellers selling on marketplaces. That's great, the marketplace collects, right? But how many of those businesses only sell on a marketplace? How many of them also have their own website that they'll make direct sales on? Maybe they have a brick and mortar store along with it. Should those sellers all be registered in all these states? We don't know. It's a matter of identifying them. And I think if you ask, whether you ask the Kansas Department of Revenue or any of our departments of revenue, how many sellers do you have registered in your state? I'm guessing that number is going to be between probably 100,000 and maybe 300,000 sellers. I don't know, I could be wrong. Some of the big states may have a few more, but that tells me that there are a lot of businesses that may not be registered. And I'm going to say on a weekly basis, we'll have conversations with businesses that have reached out to either myself or my staff, and they're asking about what their collection requirements are. There are still a lot of businesses that aren't aware of it. And we're trying to do that, and that's going to be one of our focuses as well as more education. I think that's something Streamline can do and do it for multiple states. We've tried to coordinate with our states and say, hey, you need to tell all your registered sellers they might have a collection requirement in another state. And if all the states work together on that, we should be able to get that message out to all the sellers. But that's been a struggle to get all of the states to work together on that. But that is something that we are doing. And again, the GAO is looking at that, trying to figure out, is this system efficient? The way it's set up. What are the burdens that are out there? What can the states do to fix this? And this is the cover page out of their report, and I would certainly, it just came out in November of this year, certainly encourage you to take a look at that. It's a little bit of light reading, if you're looking for some entertainment. But it does go through and it talks about the patchwork of the different states' laws and the difficulties that are there. And again, I won't get into all of the details with this. And Pat, I don't know if you have any question or anything, comments that you want to add on this just before we get to kind of where the recommendations went?
No, I think the big message from this is that Congress still is not done looking at this. And although I don't want to go down the road of predicting what the U.S. Congress will do, because I think that's a fool's errand. But at the same time, the message here is they could still act, and the GAO just issued this report that encourages them to act in certain respects.
And if you look at the list of items, these are some of the proposed reforms they suggest, and they talked about incremental things to do on a state-by-state basis, things to do on a multi-state basis, and then things to do on a nationwide basis. A lot of these things, if you look through there, they're things that you either did through Streamline, or I'm going to say you were wise enough when you passed your economic nexus law not to put in the transactional thresholds. That's one of the recommendations is to eliminate that. So I would encourage you to take a look at these things. Now, one of the things that is on there is programs to mitigate past tax liability. And I believe Kansas and just about every one of the states has some type of a voluntary disclosure program that they have in place where they can waive some, whether it's interest and penalties in certain cases that they can waive. But keep in mind that the tax agency without specific authority, if there's tax that's due, they don't have the authority to just say, yeah, okay, you don't have to worry about it. That's something they would need from you. And I have suggested through Streamline, and I will tell you, and I'm not afraid to say this, it went over like a lead balloon, but I did suggest at one point that we should all consider coming together as states and offer a very short window of an amnesty. There's sellers that are out there that want to get compliant, but they're afraid if they do come out and they do come forward that multiple states are going to come after them, and it's not going to be enough that they're going to be able to handle it from an economic perspective. So is that something we should consider? I still think it's a good idea, but again, I work for all of our member states, and I will say that, like I say, it didn't go over real well, but I'm not afraid to throw some ideas out there and let them fail. I mean, that's how you learn. But in addition to the state-by-state proposed reforms, they also had multiple state proposals. And if you look at these, I don't know why they had a hard time. They talked about Streamline in their report, but you look at these are things that Streamline has done. These are things that we're working on. Consistent thresholds, again, that's something we have to develop, but we're gonna do it. But consistent definitions, consistent processes and procedures, those are things that we've done, and hopefully they've taken note of that as well. And then on a nationwide basis, and I think this is really what they're telling Congress, this is what we think should be done, or their recommendation, which is to have them to require state participation in an interstate collaborative mechanism through which states agree on uniform standards and centralized processes. Sound familiar to what I've been talking about all morning? And that's, short of saying join Streamline, and I do think that if states were told to join Streamline and then we got together and said, all right, now let's really go through this whole agreement. Where are the problem areas? Where are the pain points from a legislative perspective? Where are the pain points from a business perspective? And how can we get through this and figure out something that's going to work? I think that is a better approach than it is to just have Congress say, states, you're going to do this, this, and this. And that's the way it's going to be. And that's what my concern is. And I think that's what our organization's concern has been, is that that's what Congress would do. And that's why we're staying so engaged with them as they're working on this to make sure that, that the voice of all of our states are heard as well. So again, I recommend Congress work with the states, nationwide parameters, balance state interests with the complexities. And again, that gets into the state sovereignty piece. So let's talk a little bit about where I see us going, where I see Streamline going over the next couple of years, kind of the current projects that we're working on. We are working very closely with the business community in the area of digital goods sourcing. And what we refer to this as really is sourcing using 5-digit zip codes. Most states, a 5-digit zip code is not going to get you to the proper state and local tax rates. It's going to get you the right state rate, but it's not likely to get you the right local rate. And the way the agreement is set up, states have to include in a 5-digit zip code the lowest combined state and local rate within that 5-digit zip code. So if you've got a 5-digit zip code in any spot in there, there's no local tax, and that's all that a seller has to base their tax on, they don't collect any local tax. Local governments end up losing out on it. We also have a database set up on not only the 5-digit zip codes, but the 9-digit zip codes. And just out of curiosity, how many of you know your 9-digit zip code? So we're at about, less than 20%. So, and then we also have it where you can use a street address. But keep in mind, this is using technology. And you can put a street address in. If you type the word street, when you enter it, and I type the letters ST, and you're trying to do a computer match, and the state's database uses STR, guess what? It's not going to find it. So we need to create the uniformity there. And the USPS has got some very good direction on it, and we are working on a uniform database for all of our states. And then hopefully we will get all of them to set their databases using those same parameters. But again, that's something that we're working on. We are also working on a combined online filing portal. One of the things, we surveyed every one of the sellers registered through Streamline. One of the things that they have said we like is our central registration system. But they said that's great, but even after we register with you, we then have to get 24 logins, 24 passwords, and fill out 24 different sales tax returns every reporting period. Isn't there a way we can do it all in one spot? And that's what we are in the very early stages of developing it. But in effect, would let a seller come in, select the state, and boom, here you got your simplified electronic return. It's uniform. Every one of our states accepts it already, that format, and be able to have a seller do that in one spot. If they've got zeros, we're setting it up, because there are many times where a seller will have transactions in a state one month, but another month they might not have any, where there'll be a simple checkbox, fill this one out with zeros for that monthly return for that state. So we are working on that. You might be familiar with FTA and MTC, the Federation of Tax Administrators and the Multi-State Tax Commission. Those organizations are both primarily work with your tax administrators. Our organization is unique in the sense that we want legislative involvement with it as well. We don't want just the tax administrators. We want the tax administrators and the legislators, because again, there can be different perspectives. But we
And
are
the
working
business
on,
community.
and well, we include you once in a while, Pat. But we're trying to work closely with them, and I've actually done some presentations to them as well with respect to having some of their non-member states participate with us. So we just think getting us all moving in the same direction, having these discussions is really what we need to do. And then encouraging, obviously, the non-member state participation. Other thing is just, our education, I touched on that. We know that we need to do that. We know we need to get out and educate remote sellers. They need to learn what their requirements are, and they need to know what tools we have available to them. And if they're not sufficient, we need to look at revising them. We need to look at improving them. Mentioned the federal legislation, anything that's going to overturn Wayfair. We're pushing back on that. We think that our states are, again, in a very good spot. Foreign sellers. How do you identify foreign sellers? When they're selling digital goods into the country or to purchasers here, how do you ever find them? What authority do you have to pursue foreign sellers? Now, I'm saying foreign. I'm not saying from a different state. I'm saying foreign country. And we need to be working on that. And then doing more disclosed practices and best practices, really providing guidance to sellers, telling them what the states are expecting. Talk briefly about our successes. Right now, we have over 20,000 active sellers registered. And when I use that number 20,000, we probably had about 25,000 that have actually registered through the system. But as you know, businesses come and go. Some start, they fail. They unregister. Some register and realize they don't need to be registered. They'll unregister. That's fine. But this is our active number of sellers was registered. It was actually 20,000, I think 800 and something as of December 1st. We are seeing about 200 to 300 new sellers, a net increase of 200 to 300 sellers every month right now. And that's what we have been seeing since the Wayfair decision. Part of that is it takes sellers time to get their systems in place. But as they get them in place, and when they get them in place with our certified service providers, then they start coming forward and they start registering. Again, over a 500% increase in registration since the Wayfair, just what are registering through us, and over $6 billion collected by our member states. And this graph really shows, what's happened to our registrations, because this is from 2009 all the way through 2022. And can you guess where the Wayfair decision happened? Just before it really took off. And again, we're seeing that as a steady line going up, and we really aren't seeing it slowing down at all. So that was the main information that we wanted to cover. The rest of the information that's in there talks about information that we have on our website. This should be your #1 bookmark in your computers, but just so you're familiar, if you get to there, that is our real website, in case there are folks that are out there trying to say that they are doing streamlined sales tax. So we do know that some of that's out there. And again, I would certainly encourage you to spend some time taking a look at that information, seeing what we've put together. I'm always open to ideas, ways that we can get better, ways that we can improve information that we need, and certainly open any discussions with any of you as well. So unless you want me to go through all of these pages, I'd be glad to answer any questions.
Yeah, we have a question here from Senator Tyson first.
Thank you, Mr. Chairman. Thank you again for your presentation. I have two questions and then a couple of comments, but first I'll ask, what's the smallest vendor or seller that you have participating in the system?
So I will tell you, we don't get, Streamline itself does not get any information about a specific seller. So the states get that. Now, I can tell you from talking with our CSPs that they have had sellers that have had less than $10,000 in sales in all of our member states combined that have used their system and been able to use it successfully. On the other end of the spectrum, we've had them in the billions of dollars that have also used those systems, and it's been successful.
No, that's helpful. Thank you. And also, we have a situation, I know it's not just Kansas, but other states also, that we have government entities or nonprofit organizations competing against for-profit businesses. For example, the for-profit has to charge sales tax, but the government entity does not collect a sales tax. So where does Streamline land on this issue?
So we would say we're going to leave that up to the states, because those entities that don't have to collect It's one of two reasons. One, it might be under federal law that they're prohibited from being able to require to collect. Federal governmental agency, for example. But other entities, most states have some type of a nonprofit exemption in place. Some of them say if your sales are under X amount as a nonprofit, you don't have to collect. But those are set on a state-by-state basis. I don't know what Kansas law is as far as what the requirement is for them to collect or not collect. But if it was a nonprofit organization, let's just say it's in Wisconsin, and they're making remote sales into Kansas, those sales are still going to be subject to whatever Kansas law is. So they should be on a level playing field with all of your Kansas, at least your Kansas nonprofits. But it depends on what's allowed in under your law.
Okay, I think we're going to have to do more research and make sure. So what I'm hearing, though, is it wouldn't take us out of compliance if we sales tax exempt those businesses that are competing against government entities.
Correct. You can put in effect, you can put in, I'm going to say, any type of entity-based exemptions that you want. So it depends. So in effect, they give a certificate and say, I'm X type of a company, therefore I'm exempt, or X type of a nonprofit. That's done on a state-by-state basis.
Okay, if I may, Mr. Chairman, I would like to request some information then from legislative research. I would request a couple of items. One is a fiscal note on that. If we were to remove the sales tax on government entities, I know that's a heavy lift, but also I would request on the 100,000, I'm all about fair and level playing field. And if we're exempting online purchases at 100,000, what would be the fiscal note to address the in-state brick and mortars for the $100,000 exemption also, so it would be a fair and level playing field. And I would ask, I think you guys have done a great job. I have a completely different experience going through the process with you. I appreciate your willingness to work with me and to help guide me through the process. And I would put this on Kansas that in our report, we recommend that we become more active in this process if we continue our membership especially, and that we do approach legislation on who the voting member responsibility is. I think we absolutely need that. And the other thing, you've opened my eyes, we need to make sure that we are deciding on gross versus, I mean, we established it in statute, but going forward, we need to make sure that we're that $100,000 fresh threshold is on the right amount of money. So, thank you.
And can I ask the question, you talked about if you allowed the in-state businesses the same 100,000, if you were going to go down that path, would you also then be exempting the purchasers from that tax? So that if the seller doesn't collect it, does the purchaser still owe the use tax? Again, just something else to think about in there, because even if it's a remote seller under the 100,000, and so they don't have to collect, the purchaser still does owe the use tax. So would that in effect be done the same way for the purchasers? Again, just an idea to.
Right, we absolutely need to look at that so that we do have that level playing field. And I'm hopeful that we can come back and report to this committee too, that we did pass the manufacturer's coupons portion. If those of you that didn't know, that's what I have been working with this group. It was a first test and a good test of how the process works and how we are able to move forward. And I would suggest Senator Peck reach out to him so that we can start that immediately and get the sales tax on holiday on school supplies addressed in Kansas. Thank you, Mr. Chairman. And thank you very much.
Thank you.
Fred, and thank you.
Thank you.
I was just going to add with respect to the school supplies. I mean, I would invite was it Senator Peck that mentioned that to contact me, because if blankets are included in school supplies, I would have a concern with that too. I couldn't find that, but when I looked at the agreement during break, but I would invite that conversation, because I would have the same concern.
Committee, any further questions? I just wanted to make a comment as a member of the tax committee. I've always found your website very beneficial. I could find sometimes it takes a little bit of reading, but I could always find whatever I needed to. And thank you for providing that, because there's a lot of questions. Never having been a part of a presentation like this, I wasn't really sure what all Streamline did, what they didn't do, the definitions, just the bylaws and how all that was handled. So just wanted to give you kudos on that, because I've always been able to find out the information I needed to by going to the website or giving you a call.
Good. Appreciate hearing that. And again, other ideas, let me know. And if anybody really wants to get down in the roots sometime in the weeds on these issues, let me know. I'd be glad to go further.
Just plan some time, huh?
Yeah, exactly.
Pat, did you have any closing comments for the group?
I did not, other than to thank you very much for your time. I know this was a lot of information, and Craig and I are full-on tax nerds, but we know that you may not be. So we just want to thank you very much for your time. And if you have any questions or follow-up, please do not hesitate to contact us.
As Senator Tyson mentioned earlier, I think tax nerd is also probably one of those subjective terms. So. But thank you again, both of you, and to Fred as well, for taking the time to come visit with the committee. This has been a lot of information, but I've learned a tremendous amount this morning.
Good. Thank you. Appreciate you having me.
Thank you. Committee, at this time, I think we'll move on to Edward Penner from Legislative Research to give us an update on some of the requests for information from our last meeting.
Thank you, Mr. Chair, members of the committee. You should have in front of you, from me, it's a stapled packet with kind of a table of contents on the top of it. This captures what I got in my notes of follow-up requests from the last meeting. The first of those is during my CRE presentation, there was a request for some detail on the impact of the Apex project and the Panasonic agreement. You can see that on the second page, and the assumptions that went into that. It split it out between the corporate rate reduction and the Apex agreement itself. At this point, when we met in November, the corporate rate reduction was not actually certified from the Department of Commerce over to the Department of Revenue and our office, and I believe the Division of the Budget gets that certification as well to happen, but that has happened since that time, and so that will go into effect in tax year 2024, and so that first $25 million is pretty well firmed up there now. But the Apex incentive with Panasonic itself, those numbers, the approach that the group took, as I mentioned back at the November meeting, was kind of a really what we think of as kind of our maximum likely exposure here, which is, of course, is not necessarily the same approach that we take in setting the actual estimates, where we try to get our most likely case. We took a bit more conservative of an approach here, and we really don't know that, because of the fact that we really don't know exactly the timing of this. It's basically dependent upon when Panasonic turns in their tax forms. The second set of information is information that the Department of Revenue provided, and this is items 2A and 2B. This is in response to requests that Senator Holland had for kind of the question of who is it that is paying tax on Social Security benefits and retirement benefits, and trying to split those out by kind of income level. And so you can see that is split out by KAGI brackets, and you can see the number of returns in each of those brackets with that tax, and the amount of the impact, and then the average for each of those brackets. The one thing I do want to draw your attention to here is this is Kansas adjusted gross income. If this was federal adjusted gross income, everything below $75,000, of course, would be zeroed out, because that's the threshold that we use. But we use FAGI threshold. FAGI is the threshold amount in our statutes. KAGI does, of course, have some potential differences because of the addition and subtraction modifications. If you'll move on to the third page, it's actually the back of the second piece of paper. You see a horizontal table like this. That is a request that was made of related to that same topic, and that was the question of kind of what is Kansas migration patterns, inflow, outflow, as it relates to specifically individuals aged 65 and over. In order to put that into context, I also included the all ages column from the IRS data. This is the years 2020 versus 2019. That is the most recent IRS data that was available for the migration of revenue across years. If you look at the next page, this is the same kind of set of questions, and that is related to where are these Kansas taxpayers going to or coming from as they migrate. And if you look down there, you'll see that Missouri is by far the largest state that has Kansas migration. I should say this is not actual taxpayer data. The IRS data doesn't provide the location information, so this is Census Bureau data, and this is actually 2019, so this is 2019 versus 2018. So that accounts for part of the distinction in the data here as well. The next pages, and I believe there are about 6 of them, or three sheets of paper total, maybe a little more actually, are the testimony from 2019 Senate Bill 174. Representative Miller requested this information. He recalled that he sat on the Senate Committee on Assessment and Taxation at the time and thought that this might be beneficial information because it does include certain migratory information, some news articles, but also it includes KPERS data in terms of where Kansas's KPERS beneficiaries currently reside and the amount of total benefits going to those. It also does include kind of some further information on taxpayers at the time with Social Security benefits. The KPERS data has been updated since that time, and that is the following page, the one that has the big orange bar across it. That is the most recent KPERS monthly benefits. KPERS provided that to me last week. Now I'm on to the next to last page, which is the front of the last piece of paper. This is a request from Representative Miller as well for the residential parcel count data. He requested it back to 1992. PVD checked into this. They only have this data going back to 1998. And so the information is provided back to 1998. I started to do some projections backwards from there in 1992 based upon the kind of rate of change here, the average rates of change. And I realized that when I do that, I usually get requests to do it a different way. And so I stopped and decided that I would just wait for the specific request in terms of how to do that before I put the fabricated line on the graph myself. And then the final page is information that was provided by PVD as well. And that was a request. I do not actually recall off the top of my head which committee member made that request, but during his presentation, Director Harper mentioned a possible recommendation for a statutory change as it relates to appraisal courses and their approval by the Kansas Real Estate Appraisal Board. And this is the language that PVD, I believe, has also provided to the revisers to potentially be used for a bill draft for that topic. And so that is everything I have here. The only thing that I do also want to mention is that the Department of Revenue provided updated versions of the same spreadsheets that they had provided last time, but with the additional information that the committee members have requested. Those have been provided to you digitally here within the last few minutes. It was quite difficult for them last time to print those out in a legible, usable format, and that difficulty is maybe even greater with the updated ones, since basically what you requested was additional information. And so I thought just providing that digitally would probably be more helpful to all of you than having 35 some pieces of paper that you have to flip back and forth numerous times in order to get to what you're actually looking for. So with that, I'd happily stand for questions on this.
First of all, Eddie, thank you, and thank you to Department for compiling all of this information as requests. Committee, are there any follow-up or additional questions regarding this information? Seeing none, or did you have? Okay. Seeing none, thank you for that, Eddie. Well, at this time, I'd like to open it up for general discussion. Just as a quick review, in addition to this meeting and our sales tax, or the streamlined sales tax discussion, the prior meeting, we had a discussion on inactive and unused provisions and authorities, taxing entities. We had a discussion on income taxation of Social Security benefits and retirement income, and the property valuation uniformity would like to open it up to discussion on each one of those items. Just for efficiency, I think we'll take them one at a time and see what we want to put in our recommendation to the 2023 legislature. But the first one would be the inactive or unused taxing provisions and authorities in Kansas. Has anyone had any feedback from any of the entities or organizations? A lot of the tax credit things that we reviewed had actually expired, so that would not affect anyone from this point going forward. I did not hear from anybody. I don't know if you did, Senator Tyson, but obviously, I think as I said in the last meeting too, this would become a bill. We'd have to have a hearing on it, so those entities, if there was an actual local entity that we were going to repeal that authority, they would have another chance to come before the legislature and plead their case on why they needed to retain that tax authority. But yes, Representative Amix.
Thank you, Mr. Chairman. I did have one individual approach me about one of the unused, we'll call them one of the unused pieces that are is in the current legislation. May have gone through a time during COVID when it was underutilized, and will they have the opportunity to be able to look? It was underutilized to the point because prices of fuels had changed and those kind of things. So there will be a big time look at this, won't they, and making sure that we're not getting rid of something that should automatically remain in place as prices, go up and down, and on some of the commodities. So.
Certainly, and I think when we were reviewing that fairly extensive list, there were some that had been used, and then because of certain situations, maybe they had not been used recently. But I know there was quite a few that we had put a provision into statute, and it had never ever been used for a number of years, and then there was a lot of them that the authority had expired time-wise. So I guess I would propose a recommendation that the 2023 legislature would look at any expired and unused provisions, and we can add any others at the time, but I'm not going to get into the details and list all those out specifically in our recommendations, but it would be nice to clean up our tax code a little bit. Good discussion. Okay. I visited with Eddie beforehand. I'm not going to go ahead and take a motion and a vote on these. It'll just be kind of general consensus. If there's something that we are at odds on throughout this list, maybe we can take a quick little vote, but I think it'll just be by general consent, and we'll present this recommendation. The next item was Social Security benefits and retirement income. It was my observation, and I could be wrong, this is my personal observation, but it seemed like there was substantial interest in removing the cliff at $75,000 from 0 to 100%. I know we worked well last year trying to develop a solution to that. It would be my suggestion that we add in that recommendation to remove the cliff and also remove the marriage penalty. Right now, it's $75,000 whether you're single or married filing joint. It was my understanding, just observing the conversation, that was the general consent of the committee. Welcome any discussion on that. Senator Tyson.
Thank you, Mr. Chairman. I would add to that, I think the calculation that we came up in conference committee to eventually remove the state sales tax or state income tax on Social Security was a great equation. We can tweak it a little, be a little more aggressive or less aggressive, but I would hope that would be part of our recommendation also.
Yes, I would agree with that, and it would be my intent to include reduction and elimination of the Social Security. Any further comments or discussion on that one? I think that covered all the notes I had.
Thank you, Mr. Chairman. We did discuss retirement accounts also, that we consider the equation in conference committee or adjusting that equation so we could gradually remove it or at least decrease it so it's not such a burden. I would also suggest that we take a look at the entities that are not paying any income tax. Most of them are treated as a regular IRA or a Roth IRA, but our regions do not pay going in or coming out. And so, again, we need that fair taxing authority or tax burden to all Kansans. And so I would ask that the full body look at that too, if there is no objection.
No, I agree. Fairness and equity is a big part of tax policy, so I think that would be wise to include in the recommendation as well. Okay. Any further thoughts on this topic? Seeing none, we'll move on to the property valuation uniformity. Did we have any specific instances or anything that we wanted to look at regarding that? I didn't have a lot of notes on that. I know a lot of it was looking at the presentation. Some of it is Board of Tax Appeals. Some of it is the local appraisers and things like that. I didn't know if there was any statutory changes that came to light from our last meeting or that you'd thought of to consider as a recommendation. Representative Amix.
Thank you, Mr. Chairman. In the last meeting that we had, we talked about residential assessment rates. Having the committee look at that and see if any adjustments need to be there. I think it would require constitutional amendment because of the change in that. I think that's something that's really important to look at as we look at the numbers continue to blossom under residential real estate especially. So I would really definitely encourage the committee to be looking at those and taking a really hard look at it.
Yeah, and I agree with that. I know, I can't remember if we got the number of households. I know when we were having that conversation, you'd asked the percentage, and the information that you and Representative Miller had presented showed how the percentage is increasing. And I would be interested to know, looking at the households, is it proportional to the growth? Obviously, we're building more homes in the state. We're not tearing more down. And as ag land is reduced, as urban sprawl and new homes are built, that does reduce the amount of ag land. But is it proportionate? I mean, are we overtaxing the residential burden? I think I would like to take a little bit more look at that before we had included in a recommendation. But did you have a comment?
Thank you, Mr. Chair. You know, as you asked for the percentage figures, and I think the last time that we had the adjustment was in 90 or 92. And I think at that time, if I recall, and, you know, the percentage on residential was at 30%. Today it's at 54%. You know, I just really encourage, you know, the committee to really look at those numbers and see, you know, if it's just, you know, blowing totally out of line, which I think it kind of is. But anyway, I would hope that we would take a really hard look at those.
Senator Tyson.
Thank you, Mr. Chairman. I think that your proposal for property tax valuation review would cover that. And maybe we could just firm up the language and recommend that the legislature not only review the property tax valuation, but also our process for establishing those valuations. That would include the Constitution, legislation, and PVD. They use directives instead of rules and regulations, or if they are using rules and regulations. But that way the legislature take a deep dive on it this session to help. That's one of the biggest items that we hear about from our constituents is our property taxes, not just personal, but business also. We are literally taxing people out of their state. And it's a local tax, I understand that, but we've got to get a grasp on this. Thank you, Mr. Chairman.
Thank you, pardon me. If we want to have just a general recommendation, I think that would be what we put in place here, and we can work on that during the session. Maybe even if we have something specific defined, we could even request a post audit on a certain area if we needed more information. Is that clear as mud, Eddie? If we do you need any clarification from us?
I think I've got enough to work with.
Yes, Senator Pack.
Thank you, Mr. Chairman. I apologize to the chair, to the vice chair. I was not at the November meeting. I was in Dallas at an intense 4-day legislative meetings, but I have one simple question. I'm not going to make comment Was there any discussion, actually, I guess it's a two-part question. Was there any discussion as it relates to county appraiser being an elected position? And the second part of that question, this will be to staff, has there been in recent years a discussion regarding making the county appraiser an elected position, which would make them more accountable to the citizens? Thank you, Mr. Chairman.
Senator Tyson fielded that question. So.
Thank you. I would be glad to. Thank you, Mr. Chairman, and thank you for the question, Senator Pack. There was not discussion, the comment was made during committee, but there was not discussion for a recommendation or enough information for this committee to make that. However, I have talked to the majority leader. That bill will be introduced in the Senate Tax Committee next year. So we will discuss it. So it doesn't need to be a recommendation for this committee, but that conversation will be had.
Yeah, I know that has been discussed in the past. I'm not sure, even before my time in the legislature, as when I was a county commissioner, I know it was a discussion topic, but I can't remember if it was Senate or House, exactly what the discussion was, but yes, Representative Stogsdill.
Thank you, Mr. Chair. I'm subbing in today for Representative Miller, so I wasn't at the last meeting, and I don't know whether this was discussed in any kind of depth or not, but there's an awful lot of disgruntlement in my district, and I think throughout Johnson County and Wyandotte County on the food sales tax, and why we can't take all of that off immediately. And I would certainly like to revisit that when we go back into session in January. And there was also, I think, a great deal of amazement and again, disgruntlement when we have a bill to take the sales tax off of over-the-counter medications, which really would impact, have a positive impact on a lot of people who can't afford prescription medications. And of course, we don't add sales tax onto prescription medications, but we do to the medications that a lot of our lower and middle income people use all the time. And when a bill like that passes unanimously out of tax committee and it doesn't even get a hearing on the floor, I think there was some real anger from my constituents and stuff as to why not? What is wrong with the process up there when you have a bill like that that would benefit those kinds of people and stuff, passes through the committee unanimously and doesn't even get a chance for discussion on the floor. So I think that's something we ought to talk about. May not be as much tax as it is process, but the two were certainly combined on that, and I think that it's a real concern to my constituents.
Yeah, the tax exemptions was not really one of the defined scopes of the interim committee here, so we did not have that discussion, but I'm sure it sounds like there might be some discussion when session starts, so. Very good. Any further comments or questions from the committee?
On that topic?
On that topic. Okay, moving on, our next scope for the committee was the streamlined membership and participation. Based on our discussion today, I know Senator Tyson had made the comment. If we wish to continue that, I would like to see some statutes changed to make us more aware and more involved from the legislative side in that process. I'm not sure exactly what those statutes, what chapter and section that is, but we've got some very, very qualified staff back there that will help us out. But I think that needs to be part of the recommendation, who the voting delegates are and the comments that you'd made about who gets to vote and our participation in that. But are there any further comments on streamlined or anything that we would like to include on our recommendation? Go ahead, Senator Tyson.
Thank you, Mr. Chairman. I think that we should recommend that the body of the whole, or the legislature, take a look at the taxable $100,000 threshold. I think we should evaluate that on how it was implemented and who it impacts, and if that needs to be amended.
So to take a look at that threshold level, and I know what they were saying, they wanted some uniformity there. Are we wanting to look as it pertains to Kansas, or look at, see what other states are doing, or just?
Thank you, Mr. Chairman. I think we should look at other states also. I know the 100,000 was what was defined in the lawsuit, and that's how we landed on the 100,000 mark. I just want to make sure that we're not impacting our brick and mortars negatively, that our online vendors have an advantage over the brick and mortars, and that we are taxing the correct dollar amount, whether it be, I'd like to see that threshold as high as possible for all businesses. But I know somebody told me I would give it all away if I could. Well, I would just give it back to the taxpayers. So thank you, Mr. Chairman.
Kind of along the lines, if you don't mind, Mr. Secretary, I know we had in Senate Bill, was it Senate Bill 50, the marketplace facilitator, we had removed that line item on the individual income tax form. Would it be easier for Kansans that are willing to remit that to take a look at adding that back onto the form? That way, these people that don't qualify for these thresholds still can remit that. Would that be an easier, more efficient way to do that than requiring them to register with the state? Okay. Oh.
It would be advantageous to have the line back on the return so that a taxpayer who wanted to remit compensating use tax on a purchase they made where the tax wasn't collected, they wouldn't have to register. And again, just having that option there, I think, would be meaningful for them.
And I know the compliance issue, it's voluntary, so it's tough to monitor that compliance issue, but not to toot my own horn, but living in Colorado, that's something that I usually did on my income tax return, because even if I did pay sales tax, the sales tax rate in Colorado was 4%. So you're responsible for technically the difference in the sales tax rate there too. So I always went through and completed that just on the estimates. I wasn't enough of a tax nerd that I'd go through all my receipts and calculate it exactly. But there was a little chart on the instructions that showed you how to estimate that, and I think it would be wise to take a look at putting that back on if that would reduce a burden to the department and to Kansas taxpayers. Okay. Yes, Representative Kessler.
Thank you, Mr. Chair. As well as, while we're on that subject, how about like with small businesses that might make a large equipment purchase maybe once every 10 years or something? Is there a way to maybe line item that on there also without making them register and do monthly filings every month for the next, until they decide to cancel?
And this would be a liability that would be of some magnitude, but at one time.
Yeah, let's say a small business that's a small convenience store that bought a new cooler or something, you know, they spent $40,000 or $10,000 or whatever, but the state forces them to file for a compensating use registration. And at that point, and then they have monthly filings after that, even though that may be they may not make another purchase for 5, 6, 7, 8 years, but they still have to do this monthly filing purchase. Is there a way to maybe line item that on a business that for these super infrequent filings, kind of like we're talking about personal?
I'm thinking the legislature changed the thresholds. That will take effect January 1, and I'm trying to think what those are. I think if you have a liability of 1,000 or less, you file annually. If you have a liability of 4,000 or less, you file quarterly. And then between 4,000 and, I guess, and above, it's monthly. So, but we can still look at that. I understand where you're coming from if it's an isolated.
Until today, I was unaware of the multiple different filing, whether it was monthly or quarterly to put it on your, or yearly, I guess. But even so, for a business that may only purchase a large item like that from out of state, equipment-wise, very infrequently, I mean, that would be probably something that's easily forgotten about and potentially bite them in the rear, you know, when that never got checked off.
Depending upon the
It's really
nature of the
unnecessary.
purchase, they may not owe tax at all if it's if it's a business and it's an asset that's used in that business.
Any further discussion on the streamline or anything for the secretary on that issue? Would it be the recommendation to, at this point, continue our membership in the streamlined as long as we take a look at our level of activity and our participation on the governing board? Senator Tyson.
Thank you, Mr. Chairman. I don't know, I guess I won't speak for the committee, but I would like to see us take a deeper dive on streamline too. We heard a lot of good stuff from how it impacts the businesses and the availability, but I'd like to make sure we're getting the full picture on that. Yeah.
I would agree 100%. And one thing you just touched on, I'd like to visit with the businesses. I'd like to visit with our state retailers, any large out-of-state retailers that do business in Kansas. What are the benefits of this? What do you see on your end? Because I know Mr. Johnson said that they work heavily and depend heavily on the business entities. I can't remember what the name of the business group was, but that's probably my main concern. I know there's a lot of advantages to participating and being a member in the streamlined organization, but I know it creates difficulties at sometimes too. We have ideas that we want to put through and we hear that may put us out of compliance, and it might just put the stop to that idea. So if there are ways that we can, as Craig had said, you've got to find that balance there, that happy medium. So I would agree.
If I may, Mr. Chairman, in the past, it's not so much now, but in the past, it was used as a threat. And I think Senator Peck alluded to this. If they wanted to try to stop legislation or didn't agree with legislation, the fiscal note and the threat of streamlined compliance would be an issue for us. But that's why I just recommend, I hope we recommend that we take a look at it. And what we heard today was great information, and I appreciate you bringing it before us because it did open my eyes in a different perspective. So thank you, Mr. Chairman.
Any final comments, Representative Turner?
Thank you, Mr. Chairman. Say on that same topic, I know, excuse me, Senator Tyson asked a question. I had a question, and I think Senator Erickson had asked for some more information on states that haven't participated in Streamline. Am I misremembering or? Yeah, so I think we have some more information coming that might help us answer the question, and I think that's still left open. Okay, thank you.
Yes, I certainly don't think we're done with this discussion, and maybe we can coordinate with House and Senate tax to make sure that if we take a deeper dive, if there's some folks coming in from outside agencies, they can hit both of our committees on the same day and be efficient with, or maybe even a joint committee meeting.
That'd be cool.
So, last chance, any final thoughts on the streamlined section or anything for the committee as a whole? Staff, is there any further guidance or anything you need from us?
The only thing I would say is that just to give everybody a heads up in terms of how this works, although I think everybody on this committee's now been on interim committees, is that over the next couple of weeks, our office will compile the committee's report, and it'll run through our editing process. Once that's been edited by our editors, that'll go out to you for your review, and you'll get a deadline in the email sending it out to you by which you need to respond back to me with any sorts of, if you think that I've misinterpreted any of your comments today or not captured something, as I think usually the more common one that I get, send it back to me to try to revise that. Usually at that point we determine if that rises to the level of, a really substantive change that needs to be resent out, or if that's almost more of a technical change that we can just incorporate without resending it out. And that's how this will go. And the same thing will happen with the minutes of both the November meeting and this meeting.
After that, any questions, committee? Seeing none, thank you all for your time, both days, and for those of us, or for those that joined us just today. If I don't see you before then, have a Merry Christmas and best wishes, and we'll see you when session starts. Thank you. We are adjourned.